Okay. Calling parties on Bolden, case number 1955865. The people of the state of Michigan versus J. Lamar Bolden. The defendant is charged with count 1, controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic less than 50 grams. Second or subsequent offense notice, habitual offender, third offense notice. The defendant is also charged in case number 1955325. People of the state of Michigan versus J. Lamar Bolden. The defendant is charged with count 1, controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic less than 50 grams. Habitual offender, third offense notice. These matters are scheduled for probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Remax on behalf of the people.
Good morning, Your Honor. Samuel Chirikian appearing on behalf of Mr. Bolden, who is not present. If the court will recall, Mr. Bolden is in federal custody, having been sentenced to 24 months by Judge Edmond on April 21st of this year.
Okay, are you requesting to waive his presence?
Yes, Judge.
So ordered. Okay, what's your pleasure, sir?
Well, Judge, the prosecutor made an offer. I did send that on June 21st. I sent a letter containing that offer as well as the plea form to Mr. Bolden, who at the time was being housed at the Oklahoma City Federal Transfer Center. I have never received a response from him. I don't know if the assistant prosecutor is able to track him down, but he's clearly within the federal system presently, Judge. And he needs to be brought before the court by Zoom or by writ or whatever the court chooses.
Okay, so it sounds like if an offer has been made and you've tried your best to relay that offer to him, we need to schedule for another, I would imagine, a PCC via Zoom, and a Zoom writ needs to be effectuated with the issue remaining. Where is the defendant? Do you know, Madam Prosecutor?
Your Honor, I have been trying to hunt down Mr. Bolden. I did contact the Milan FCI. I believe that's a holding facility that Mr. Sharikian gave me a phone number to. They told me that he was in transit to another facility up in Kentucky somewhere. And they couldn't give me any information in Kentucky because he was still in transit at the time. And they said that they'd have somebody reach back out to me and give me more information. Nobody did. I called them again. Nobody answered, nobody picked up. And then that's where we're at right now. So he is not at both of the facilities that Mr. Sharikian and I think that he's in right now. And the only thing I have is a phone number from some legal department who nobody answers to over there. So I really don't know where he is at this point.
Okay, well, let's, I think the only thing we can do is adjourn for another PCC for which the defendant's presence will be mandatory. The prosecution will need to perhaps put someone in the prosecutor's office on top of this to get to the bottom of it, because it sounds like you have exhausted all of your efforts in that regard, but there has to be someone that can provide some answers so that we can at the very least effectuate a Zoom writ. And let's say if today's the 29th, why don't we set this for, Mr. Sharikian, why don't you set the date? Do you want to set it for maybe 2 to 3 weeks out?
That would be fine, Judge. Let's pick a day.
Okay, August 12th at 8:30?
Judge, I've got a live exam that day. Why don't we do it on the 10th?
Okay, August 10th will be the new PCC date. And again, the expectation is that someone is going to be able to get to the bottom of where the defendant's located and effectuate that Zoom writ. So they would likely need to do that rather quickly, as those Zoom writs do need time to process. In fact, you know what, Mr. Sharikian, why don't we set it for the following week? Because if it takes a couple of days to figure out where he is, I don't want the time frame to prevent that Zoom writ from being processed. So can you date on the week of August 16th?
I can do it the 16th, Judge.
Perfect. August 16th And I know you share this docket with another prosecutor, so between the two of you, if you could make sure that there's someone from the prosecutor's office that can assist with this very fine detail. It's a necessary detail because we need the defendant here.
All right, Judge, we'll see you at 9 o'clock on the 16th.
Yes, sir.
Thank you.
Thank you. Have a good day.
You too.
Are the parties on Patrick Henningberg present? Ms. Reed?
Good morning. I am present. I have made an effort to contact Mr. Hemmingsburg, but I will acknowledge that you're going to call the case.
Okay, I'll call it. Calling case number 2060725, the people of the state of Michigan versus Devontae Patrick Henningberg. The defendant is charged with count 1, weapons carrying concealed, commission of a felony with a motor vehicle advisory. Judge, this is scheduled for a probable cause conference, but this was the matter that was scheduled for a preliminary exam yesterday.
Okay, thank you. Appearances, please.
Good morning, Your Honor. Remind Food on behalf of the people.
Good morning, Your Honor. May it please this honorable court, Tatsuni Reed on behalf of Devontae Patrick Hemmingsway.
And your client.
Your Honor, my client is not here today. I did put in a phone call to him this morning. However, I will acknowledge that I did not have this in my book yesterday. Therefore, I didn't give him a call previous. In the spirit of honesty, I don't want it to fall on my client. I could have used a little more due diligence. This case must have been scheduled a long time ago. I've changed planners since. If you would allow me one more PCC so I can mail him a letter. And then if he doesn't, we can case this.
Absolutely. So I will waive his presence for purposes of scheduling this new PCC. Let's see, today is the 29th. Why don't we set it for August 12th or August 19th, 2 to 3 weeks out, whatever is your pleasure.
August the 12th will be off, Your Honor.
Okay, new
And I'll get that
PCC.
letter out.
Perfect. New PCC, August 12th at 8:30 via Zoom.
Thank you, Your Honor.
Welcome.
Do I have the parties on Hill, Kawan Hill?
People are ready.
Calling case number 2159268, the people of the state of Michigan versus Kawan Vanell Hill. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, larceny from the person. Count 3, domestic violence. This is scheduled for probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Joe Bloomers, P77307. People.
Good morning, Your Honor. Janet Span, P43281, appearing on behalf of Mr. Hill.
Okay, Mr. Hill, state your name.
Hello, how are you?
Good. How are you? Could you please state your name, sir?
My name is Kawan Hill.
Thank you. Counsel, what's your pleasure here?
Your Honor, we'd like to set this for exam, please.
Okay. Are there any concerns regarding bond that might affect the timing of this exam?
Your Honor, at this time, there are no concerns from the people. The people are satisfied as to bond.
Okay. Madam Clerk?
October 12th at 11:30.
Yeah, that'll work.
Okay, in-person exam, October 12th at 11:30. And are there any discovery concerns?
I have received paper discovery. I don't know if there's any video or 911.
There does appear to be some video uploaded to evidence.com, which I will get to you as soon as I have to review it, and I will order the 911 audio.
Okay, great.
The bond will continue. Please make sure that you continue to abide by the no contact provision, which would include that you have no contact, either direct or indirect, with the complaining witness. That would include any form of social media outreach, texting, letters, chat, or even using another individual to communicate with the complaining witness. And even if the complaining witness comes to your doorstep, you are not then permitted to engage. So please keep those things in mind, okay? Okay,
Yes, ma'am.
thank you.
Thank you, Your Honor.
You're welcome. We're all set.
Have a
You can
great
log
day.
off, sir. You
I'm
too.
not sure. It says court. Christine Garrett. But the courtroom is scheduled just for 40, so I'm not for sure who the judge is. So you just need to sign in the courtroom for 40. Okay? All right. Mr. Blake, are you here on Rodriguez?
Yes, I am.
Does Mr. Bozzi need to be here, or can I call it with just you?
You can call it with me. Just set it for an
Okay.
exam.
Okay, I wasn't sure just from the notes what was going on with it. Calling case number 2158045, the people of the state of Michigan versus Victor Enrique Rodriguez. The defendant is charged with count 1, robbery armed, count 2, weapons, firearms, larceny, count 4 and 5, weapons, felony, firearm. This matter is scheduled for probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Read my accusation on behalf of the people.
Good morning, Your Honor. Mike Blake appearing on behalf of Victor Rodriguez, P37259. Mr. Rodriguez is also present via Zoom.
Okay, thank you. Mr. Rodriguez, please state your name.
My name is Victor Rodriguez.
Thank you. Counsel, what's your pleasure?
Judge, we're asking the court to set this for an exam.
Okay. Madam Clerk, if we could find a date, not in where we are in December, but something a little closer. October, November. Preferably.
October?
Yeah.
October 19th at 11?
That's fine.
Okay, in-person exam, October 19th, 2021 at 11 a.m. Mr. Rodriguez, please make sure that you plan to be here in the courthouse. Occasionally, we have confusion with people appearing on Zoom for their actual in-person examination date. So please plan to not only be here on that date, but arrive in advance of the scheduled 11 o'clock exam time, because presumably there will still be a screening process for which to enter the building, and you need to afford enough time for that process to occur so you're not late getting up to the courtroom. You understand?
I understand, Your Honor.
Okay, Mr. Blake, I know you came into this case after Mr. Bozzi. Do you have discovery?
Judge, I have paper discovery. If there's any video or body cams, I don't have that.
I'll check on that right now, Mr. Blake.
Okay.
Okay, if there are, if we can make sure that Mr. Blake gets that well in advance of that exam date. If you find you have any issues prior to the exam with regards to discovery, please just make sure you notify the court and prosecution, and we'll tee it up for a motion hearing.
Yes, Your Honor.
Okay, we're all set. Thank you so much.
Thank you.
Ms. Adar, what case are you on this morning?
Hi, I'm the prosecutor on Antino Beaver. I know Mr. Beaver has checked in. I believe defense counsel is Jamil Kuja.
That's true. What's your P number, please?
P84161.
Okay. Ms. Colthurst, are you here on Campbell, Jerica Campbell? I haven't checked in. I'm not sure. Does anyone else need to check in? Do you have anyone out there for a
Good morning, Madam Clerk. It's Jennifer Colthurst. Hope you and Your Honor are well. I am here on Jerica Campbell.
All right.
People are already on that call.
Calling parties on Campbell, case number 1859319. The people of the state of Michigan versus Jerica Capri Campbell. The defendant charged with count 1, license documents, plate forgery. This is scheduled for probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob Slowski on behalf of the people, P83677.
Good morning, Your Honor. Jennifer Colthurst, P52876. I appear on behalf of Ms. Jerica Campbell. At this time, I waive her presence.
Okay. Is that background noise coming from you, Ms. Colthurst?
Oh, I'm sorry. I believe it is, but I did disconnect the other Zoom.
Oh, okay. I just was making sure because it's kind of causing us a little bit of a difficulty in hearing to compete with that background noise.
Yes.
Your client is on bond and you're requesting to waive her presence?
Yes, please.
So ordered.
I am waiting for, thank you, Your Honor. I'm waiting for the discovery. I need the discovery.
So this is an older case. I'm sure I'll be able to locate it, but since it's from 2018, it would not have been uploaded to evidence.com. So I'll have to locate the file, have it redacted, and send that out to you. I'm going to get on that promptly and send it to you as soon as I can. Ms. Colthurst, I do want to let you know that we do have a plea available if your client is interested after you've had the opportunity to review discovery, and that is to reduce the license plate forgery count down to a misdemeanor, unlawful use of a license plate, which is MCL 257.256, and diversion or delayed sentencing is not available. Sentence to be determined by the sentencing judge. Let me know if your client's interested, please.
Thank you for sharing that. I will let you know.
What would you like to do? Would you like to have another PCC so you can have an opportunity to get that discovery?
Please, Your Honor.
Okay,
Yes.
so how about August 12th? Or August 9th? When are you back, Mr. Slesky? Are you back the week of August 16th?
That's correct, Your Honor.
August 19th, are you available, Ms. Colthurst?
Your Honor, I am juggling 2 other matters, but I can, I'm sure, zoom in.
What about the 20th or the 18th?
Your Honor, the 18th is less congested. That will be better.
Okay, August 18th at 8:30 via Zoom.
Thank you.
And we'll be able to make some headway, okay?
Thank you very much, Your Honor.
Thank
All
you.
right. Have a good day, Your Honor, and staff, everyone.
You too.
Thanks, everybody.
Thank you. Bye-bye.
Can you see who that is?
Division 1, what's your name?
Great shot, Gray.
Thank you.
We need Mr. Kalanga, he's in the building though, so.
Oh, okay, this was supposed to be a Zoom exam?
It's just a probable cause conference.
Oh.
Mr. Glanger's just got another case in the courtroom.
Oh, he's also got an exam though.
No, that
Oh,
was
that's
there. The clerk didn't take that out of the.
Oh, okay.
That was the magistrate scheduled that. I didn't catch it till this morning. So it's just a probable cause. else? Does anyone else need to check in? I don't have anything to call at the moment. Oh, this is one. Gray. All right. Calling parties on Gray. Case number 2159462. The people of the state of Michigan versus Rayshawn Man Gray. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, malicious destruction of personal property less than $200. Habitual offender, fourth offense notice. This is scheduled for probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Rima Yacouf on behalf of the people.
Good morning, Judge. Richard Glenn, Mr. Gray. Judge, a
Okay,
little
and your
bit.
client, can you state your name, sir?
Rayshawn Gray.
Thank you. Okay, counsel, what's your pleasure?
Judge, a little background on this. Even if you may recall, this matter was up for an initial PCC last Thursday, July 22nd. We didn't know at the time that Mr. Gray was in custody. We found out that he was. The matter was put over 1 week to today for another PCC. I haven't received any discovery, but talking to the prosecutor, she doesn't have her file. She's asked to have it recreated. So that's where we are right now, Judge. I would set it for either another PCC or an exam, but I would like to address bond since Mr. Gray is locked up on a $20,000, 10% bond. That's my
Okay, are you able to address bond, seeing as though you have no discovery, or?
No, they don't have the file. I'll defer to the prosecutor.
Your Honor,
Okay, but you said you wanted to address bond, so I just want to make sure, have you
I'm
had an
aware.
opportunity to speak with Mr. Gray such that you can make a bond argument? I also want to note, I do have an investigator's report here. So I don't know if
Perhaps
you
I
want
can
to
have a
maybe take a look at that and then recall it?
Yes,
Let's do that.
if I could ask your clerk to make me a copy of that, that would be
Okay.
great. Maybe for you too.
Yeah.
Thank you, ma'am.
Anyone check in on the 9:30? Judge, they're ready to recall it.
Oh, okay, we're back on the record in the matter of People versus Rayshawn Gray. I don't think we need to put appearances on because we haven't called any other case. What would you like to say?
Judge, we both have an opportunity to review the investigative report. Luckily, the complaint here, I'm not sure if there's any relationship between the two people, Judge. My client's 45, the complainant is 17. But in any event, there were no injuries sustained. It looks more like a property damage situation. There was a broken window with a brick, no gun, knife, or anything like that. I'm just asking for a reduction in the bond, Judge, perhaps coupled with a GPS tether. Again, whether we set this for another PCC or an exam, case has been delayed somewhat. Prosecutor still has to get the file. So other than that, I'll defer to her. Thank you.
Madam Prosecutor.
Your Honor, if people would object to any reduction in the bond, I believe the bond where it is right now currently is fair, given the representation that in the investigator's report, the defendant first attempted to open the door where the victim was seated, and when he wasn't able to, grabbed the brick and broke the rear side passenger window, and he hit the window several times. So with the victim seated in the car, I believe the bond is fair there because any reasonable person would infer that if you hit a window with a brick, that the window could shatter, glass could get on the victim and ultimately injure the person in the vehicle. As counsel stated, I do not have a file, so I don't have any information as far as the defendant's case history or any CCH that, I would have an advantage of knowing to make a better argument.
Okay, what we're gonna do is, counsel, notwithstanding the argument that you've made, I have to have a basis for which to amend a bond that's set by the magistrate in the absence of finding that there's been an abuse of discretion in setting it at $20,000, 10%, which considering the offenses that your client is facing, I don't see that is an outright abuse of discretion. So with that being said, I'm not saying I would not be open to changing it, but I would need to have a report that fleshes out more detail that would warrant such a change, such as a DSU report. So if you want to set this over, generally that takes, I would think, around 7 days for that report to kick back. Let's adjourn the
Judge, I'll be out of town on the 4th of August for the week 4th and 6th. So next week.
Okay. Tammy, is it 7 days or?
It is 7 days.
Oh, okay. So August 9th?
August 9th, yeah, that would be here in court. That'd be by Zoom. That would be a PCC.
That would be a PCC by Zoom, unless, Mr. Glenda, you wanted to set this for an in-person examination, and then we'll set it for the week of the 16th. The night. And then we could address an issue as well. I don't want to, given that your client is in custody, I don't want to drag out the inevitable.
Right.
Pause for just one moment. So good morning to everyone in Zoom court. I know that this may be a different experience for some of you, but there's a couple of expectations that I have. Number one, it's that you would keep your microphone. That's really an easy thing to accomplish. Please familiarize yourself with your device to the extent that you understand how to mute yourself. There's a little button that is in the shape of a microphone, and you just tap on that. And then when you need to talk, you can simply tap back on it again, and then you're unmuted. There's also a little icon for camera. And whenever you're speaking to the court, you've got to have the camera rolling. Now, there's another expectation I have, and that is that you would act in accordance with how you would act if you were actually inside of a courtroom. So that you would be properly clothed. In fact, that you would be wearing clothes, Mr. Hill. So if you would, please put some clothes on.
Yeah, we're finished.
Well, that may well be the case.
I got you.
But, Mr. Hill, thank you. For anybody that may be appearing in Zoom court, that's kind of a standard expectation. And everyone to just simply show some respect in that regard. We're back on the record, and I believe that background noise is coming from the jail. Is that causing a problem for you, Madam Clerk? Court reporter?
Oh, no.
Okay, please proceed, Mr. Clerk.
What about the Tuesday, August 17th for exam?
Tuesday, August 17th at what's,
11.
11? Can we do that, Madam Clerk? Well, he's in custody, so. Yeah. At 11 a.m. will be the in-person examination. Now, Mr. Glenda, I'm making that referral for a DSE report.
That's fine, thank you.
It's meant that we get that report, which will be likely before August 17th. You're certainly welcome. We'll disseminate it. If you feel that there's some there, and you'd like to make a bond argument before the 17th, you can tee this up for a bond hearing, and we certainly can address the bond at that time. But for now, I'm glad that we're locking in an exam date, August 17th. You can always make an argument on the 17th as well regarding bond. And that will be set for 11 a.m. for an in-person examination, not by way of Zoom, in person, and we're all set.
All right, thank you. Mr. Gray, I'll come up and see you.
Yeah.
This is gonna be one of those days, I guess. We'll see if Mr. Callahan's out there.
Just Callahan's not up there.
No, because it's after 9:30 now. You by yourself today?
For a little bit.
Oh, okay.
For a little bit.
I haven't heard from anyone. I think everybody's in slow motion today.
Rain and clouds. Everybody is just tired of the rain.
I know.
Yes. That's exactly what I do. Okay, thank you. We're all set for 1:30.
Oh, he's down. Okay, good. He's one that was supposed to be transported from somewhere else.
Jamie, do you have a number for Attorney Callahan?
Mr. Callahan, I'll look it up and see what I've got.
His client's outside, but we don't have officers
Oh,
for
okay,
the prelim.
okay, let me see. Good morning, Mr. Callahan. This is Tammy from Judge Archer's courtroom. Okay, we'll see you in just a minute. All right, bye. He's walking in the building. This always feels like wasted time. Yeah, just, and then we're gonna be like slammed, like submerged.
Hello?
Because she liked it. Hello?
Good morning.
Mr. Callahan. Good morning to you, sir.
Good morning.
How are you?
Hey, happy to see you.
Happy to see you as well. Okay, whenever you're ready, did you get the update on your case?
I'm pretty sure I did.
Okay. Mr. Callahan, do you like muffins?
You know, Judge, I do.
and we've got one with your name on it today.
Oh, well, thank you. I'll probably pass. Really appreciate it.
Oh, boy. Okay,
Okay,
whatever
you
you're
ready? Calling parties on Turner, case number 2061933. The people of the state of Michigan versus Geronte Turner. The defendant is charged with count 1, weapons carrying concealed. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Remind Cook on behalf of the people.
Good morning, Your Honor. Evan Callahan, P30564 on behalf of the defendant.
And could you please state your name?
Geronte Turner.
Thank you. Okay, today is the date and time set for preliminary examination, set for 9:30. It's currently 9:46 by the court clock. What's your pleasure?
Your Honor, at this time, the people are not ready to proceed. Officer Eric McCombs has been subpoenaed and notified to show up to court and has not done so.
What was the name again?
Eric McCombs, officer.
And have we received a phone call from anyone downstairs saying there's someone coming up?
No, no calls.
All right, is there a motion?
Judge, I move to dismiss.
Thank you. With the time frame as it is and those representations made by prosecution, the matter is going to be dismissed. But here is an important thing for you to understand, sir, that the matter is dismissed, but it's dismissed without prejudice. And what that means, sir, is that Traver language after the word dismissal, without prejudice, means that it is possible that this matter can be reissued. Now, that's something most people don't understand. So if you have questions about that concept, please make sure you speak to your attorney so that you're not caught off guard. This is a situation where an officer has failed to show. There certainly could be a plausible explanation to explain why they did not show, thus the possibility of a reissuance. Do you have on a GPS tether that needs to be removed, sir?
No, ma'am.
All right. I just need your signature, counsel, Mr. Callahan, on this order of dismissal as you are the moving party. And the matter is formally dismissed without prejudice.
Thank you, Judge.
You're welcome.
And approach.
Yes, sir.
Then I'll slide right through there. So she has it. There you go.
Is it H-A-E? No, it's L-L-A-N-A. Okay. I was trying to look at St. Callahan. Well, I answered this.
I'm sure most people do. I just noticed it. Too bad it's Callahan the other day when I was looking it up. I was like, oh, okay.
People ask me, are you related to James Callahan? No.
Nope. Give me just a second and I'll give you a copy.
734 334 6165. All right, thank you. Thanks. Thank you very much. You folks have a great day.
You too. You too. No, no muffin, huh?
No,
You're gonna-
thank you
okay.
for the offer. I really
All right,
appreciate it.
okay.
Next time I come, I'll bring muffins.
Okay.
Okay.
They probably won't let you in with them downstairs.
That's true.
Who's that?
Oh, they won't let
attorney?
us downstairs?
To what?
They won't let us bring anything in?
Oh, I
I
don't
don't
know.
think so.
Sometimes they do. Depends on who's
Well,
in there.
That's
Yeah.
true, isn't it?
Yeah, that's like, wow, humbug.
What if I wanted to get you guys shawarmas or something, right?
Well, we'll make an exception.
Okay.
I'll go down there and get it myself.
Call me and I'll come down. They'll let me come, they'll let me go down there.
You see my ears perked up.
Hello.
That's it.
Hello.
Good morning. How can we help you?
Oh, I don't know. I was just.
Yeah, we're gonna go back on mute. Thank you so much.
Am I still in court?
Mr. Kuja.
Jeff.
How are you, sir? Mr. Kuja, are you there? Are you connecting the audio?
Hi, Judge.
Good morning to you.
Sorry about that. I had an in-person hearing and I didn't think you guys would be done.
No worries. You're right on time, sir.
All right.
I'll call it as soon as the court reporter comes back in.
Okay, thank you.
Good morning, Ms. Haydar.
Good morning.
How are you?
Good, how are you?
Good.
Good.
She's on Mr. Kuja's matter. Is, Oldham, is that your case or is that Mr.?
That's mine, it's gonna be a dismissal.
Oh, okay, we just need Mr. Sallin to get here.
I meant to ask you a question. Is this, Kalafi, was that dropped off?
Yes, yesterday.
Okay.
So I wasn't
Is it
here, so
something
I'm not
else?
sure what happened.
Can I trouble you for the file, because I can't remember if this was, oh, you did? Give me
No, I didn't know if maybe it
There's
was
something
still up there.
Oh, I don't know
But
why I
I'll
have
pull it,
this.
I'll pull it otherwise.
Latoya
Who is that?
Brewer?
Oh, I
Let me just see if I wrote it down.
Mr. Sallin out there yet?
No.
No.
This is Latoya Brewer, and I'm, oh, you know what, you may just attach something with it. Yeah, you did.
Oh, okay, I'm not sure. All right, let me scan this and then I'll call that case. Yeah,
Which one is it here on?
Beaver, and that's what Ms. Hagar's on too. Calling parties on Beaver. Case number 2159515. The people of the state of Michigan versus Antino Beaver. The defendant is charged with count 1, weapons, firearms, possession by felon. Count 2, assault with a dangerous weapon, felonious assault. Count 3, weapons, dangerous weapon, carrying with unlawful intent. Count 4, 5, and 6, weapons, felony firearm. Habitual offender, second offense notice. This is scheduled for probable cause conference.
Thank you. Appearances, please.
Good morning, Rhonda Hadar for the people, P84161.
And good morning, Your Honor. Jamil Kuja appearing on behalf of Mr. Beaver.
Mr. Beaver, please state your name.
Antino Beaver.
Could you give me video, sir?
Judge, I believe he's called in.
I'm
I
sorry.
called in.
He called in on the phone rather than on Zoom.
In future, if it is, well, tell me what we're doing here today.
Judge, so I spoke to him yesterday after the prosecutor sent me discovery. I went over it with him. He wants to set the matter for preliminary exam.
Okay, so, are there concerns regarding bond that would affect the timing of this examination, Madam Prosecutor?
No concerns regarding bond that affect the timing of the exam, but there is one thing I do want to put on the record regarding bond, but nothing that affects the exam timing.
We have an October or November date. Maybe early November.
Actually, we can do October 22nd at 10:30.
It's good for the people.
Just double check, Judge. So October 22nd at 10:30.
Yes, sir.
Do you have anything the day before or later in the afternoon that day?
No, not in the afternoon, no.
What's the next event?
That would just happen to be a light day, so we're probably gonna go on in
That's-
November now.
That's fine. I'll make it work, Judge. If
Okay,
I'll
you
make-
like that?
What was that?
You would like that date?
Yeah, that's I will make it work. I'll move the other case I have around. It's fine.
Okay. 22nd at 10:30 for in-person examination. Esteban.
I'm Esteban, Judge. I don't have, it's my understanding the defendant is out of custody, and that's fine. I just want to place on the record that I know that the defendant and the complainants in the matter are neighbors, and I just want it to be made clear that, I'm not sure if there's a no contact order. I'm assuming that there is here. But I want it to be made clear that the defendant and the complainants are not to have any contact with each other.
Okay, so there is a no contact provision in place that was put in place at the time of the arraignment. Keep in mind, Mr. Beaver, that provision applies to you, notwithstanding what the prosecutor just said. Now, certainly the prosecutor, I would ask that you contact the complaining witness to ensure they don't do anything to gaslight the situation, or just speak in a pleasant way, that they be advised not to reach out. But the order is really, the bond is on Mr. Beaver. So you are the one that needs to be very particular about having no contact. That would include indirect contact as well. No form of social media outreach, telephone, letter, texting, chat, or even using another individual to reach out to the complaining witnesses. So that's really important. Even if the complaining witness, apparently, according to Madam Prosecutor, that's a neighbor, even if they come to your doorstep, you are not then permitted to engage with the complaining witness. Do you understand that, Mr. Beaver?
Yes, ma'am.
Okay, and if there's any issues that arise, please notify the court.
Thank you, Judge.
Have you been in contact with the complaining witness? Have there been any issues or concerns?
No, Judge, I have been in contact. There have not been any issues. I just wanted to make sure it was placed on the record and that Mr. Beaver understood.
Okay, well, hold on one second. Let me just take a closer look. Tammy, I need a closer date than October. These allegations are very serious. And if they're neighbors, I don't know, I don't feel comfortable holding this off too long. Maybe something in September.
Yeah, I'm checking real quick.
You have discovery, Mr. Kuja?
I do, Your Honor.
September 9th at 10 a.m.
Good for the people.
Yeah, that works for me, Judge.
Okay, we're gonna bump it up considerably. September 9th at 10 a.m. Please, Mr. Beaver, disregard that earlier date of, that we gave just a few moments ago in October. We need you here in person on September 9th at 10 a.m. inside of the courthouse. Do you understand, sir?
Yes, ma'am.
Okay. And abide by that no contact provision, please. And we will see you then. Thank you so much.
Thank you, Judge.
Thank you, Anna. Have a good day, everybody.
Oh, one more thing, Mr. Beaver. One more thing I do want to point out is that in the event that the bond is violated, the no contact provision, this is something that I think a lot of people miss. If it's violated, your bond could be revoked. So it's very serious. I don't want to leave the record without you fully understanding that violating the bond could have a consequence as severe as revoking your bond. So please be very careful about that, considering the concerns of you being neighbors with the complaining witness.
Thank you.
You're welcome. Okay, we're all set.
All right, bye.
Not sure who's on Pearson. I believe that may be Mr. Green. That says probable cause. That should have been scheduled for an exam. But the entry was made wrong back in January.
Which one is that again?
Pearson with Miss Silver.
That's Mr. Boomer's case.
Yeah, I just want to make sure that Pearson. And it says, in the file, it says an in-person exam, but in the system, it says virtual hearing scheduled. So this is all wrong, and I will add it wasn't me. I didn't make the entry.
Wasn't me.
So I'm not sure. Mr.
I'm sorry.
Bloomers,
Yeah, what case is that?
on Pearson, that should be an in-person exam, not a probable cause, and not a virtual hearing.
Pearson.
30?
Yeah, I have it written as an 11:30 exam on my file. So I sent
Alright. I just want to make sure we didn't show up at 11:30 and
right.
not everybody on the same page.
Thank you.
Anyone out there?
No.
Ocham?
No,
Neither one of them are out there?
no attorney, no defendant. Oh,
All right. Let me make some phone calls to these attorneys.
unwillingly.
Oh, your calendar, that's right.
Thank you.
Yep, no problem.
Have a good
I
one.
told you to hold out for a ransom on that.
I had 2 of those yesterday.
One of those things, you know, you get to be 75 and you start forgetting where you've been in the last 10 minutes.
Oh, that's funny. Not you. Take care. Have a good one, Mr. Blank.
Thank you.
How's your daughter doing? Mr. Blank? Did he hear me?
I don't think so. He's gone.
Mr. Bloomers.
Good morning, Judge.
You ready? Calling parties on Bledsoe. Case number 2061947, the people of the state of Michigan versus Donisha Jamel Bledsoe. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, weapons, firearms, discharge, enter at a building. Count 3 and 4, assault with a dangerous weapon, felonious assault. Count 5, domestic violence. This is scheduled for a preliminary exam.
Thank you, ma'am. Appearances, please.
Jacob Bloomers on behalf of the people.
Good morning, Your Honor. David Kripsky, 34972, appearing on behalf of Ms. Donisha Bledsoe, who's here with us in court. Stand up, please.
Please state your name, ma'am.
Donisha Bledsoe.
Thank you. Okay, today is the date and time set for preliminary examination. Are we proceeding to an exam?
Yes, Your Honor.
Yes, people are
Motion
ready.
to sequester witnesses.
Sequestration is granted. The courtroom is already restricted because of the COVID restrictions that this court is still in compliance with. So there are no spectators in the courtroom. The Zoom gallery is relatively quiet this morning. So I'm going to enable the waiting room. And if you hear anyone chime in, it will be because I've let them in and they're an attorney. But the third tier to sequestration is that we are live streaming on YouTube. So if there's anyone watching the live stream that is either a witness or a potential witness in the matter of People versus Donisha Bledsoe, please stop from watching these proceedings, as it may preclude you from testifying in the future. That being said, are there any other preliminary matters to tend to?
None from the people. Judge.
No, Your Honor.
Okay, first witness.
Your Honor, the people called Deontay Stokes.
Good morning, sir. Could you please state your full name and spell your first and last name?
Full name is Deontay Edward T. Stokes, DEONTE
Thank you. And could you raise your right hand, sir? Do you solemnly swear or affirm testimony you're going to give us the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. You can come around here and open that gate. That wooden gate swings open towards you. Have a seat. Your witness once he's settled, Mr. Prosecutor.
Good morning, Mr. Stokes. Can you please state your full name for the record?
Deontay Stokes.
And Mr. Stokes, were you at the address of 16740 Stout on or about the date of July 19th, 2020?
Yes.
And how do you know that address?
That was my house.
Okay, at that time?
Yes.
All right. And was anyone at that house with you on that day?
Me and my sister.
And her name?
Aisha Reed.
Okay. Is there anything out of the ordinary that happened to you on that day at that location that brings you here today?
Yes.
And just briefly, what would that be?
Well, I was supposed to receive my daughter, but my baby mama showed up with, I guess, other plans.
Okay, so I'll stop you there. You said you were supposed to be receiving your daughter. Who was your baby mama?
Donisha Bledsoe.
Okay, and so you have how many children in common do you have with Ms. Bledsoe?
Just one.
Just the one? Okay. And do you see Donisha Bledsoe here in the courtroom today?
Yes.
Could you please point to her so the judge can see and just tell us an article of clothing she's wearing?
She's the one with The pink top.
Let the record, thank you. Let the record show you this identified person, the defendant.
The record shall reflect.
Okay, so, you said you were waiting and, for a child, a custody exchange, is that correct?
Yes.
Okay, and, did Ms. Bledsoe show up at the address?
Yes.
And do you recall just about what time of day this was?
I had just got off of work around 3, so it's about 4 o'clock outside.
Okay, so in the afternoon around that.
Yeah.
Okay. And did, Ms. Bledsoe show up alone or with others?
No, she showed up with others.
Okay, and, how many others?
2 others.
2 others, and were they male or female?
Both males.
And were they individuals that you recognized?
I recognized one.
Did you know their names?
Eric Bledsoe. Eric Austin, I'm sorry.
Okay. And, you didn't recognize the other one?
No, the other guy, I have no idea who he is.
Okay. So, was your child there with them?
No, my child was not even there.
Okay. And was this about the time of day you were expecting her to show up with the child?
Yeah, recently that day, she called me and said she was going to show up.
Okay. So, Ms. Bledsoe shows up with these 2 other gentlemen, and what happens next?
So as I was walking to the car, expecting me to receive my daughter, I see the 2 gentlemen get out the car. And when they get around the car, I see them both have handguns in their hand. So when I see the handguns, I immediately start backing up. And they start telling me like, no, come here, don't run, come here.
Okay. So, at this point, where was Ms. Bledsoe?
She was in the driver's seat.
In the driver's seat of the car. Okay. So you see these 2 guys get out with guns, and they're telling you to come here. What do you do as a result?
I immediately start backing up, going towards my house.
Okay. And what happens next?
Once I get to enter my house, you have to walk up like the side of my house, the stairs.
Okay.
So when I got towards the stairs, they just started letting off shots, started shooting towards me. And luckily, it's like a brick wall right there, and I just ducked down behind the brick wall.
Okay. And do you recall about how many shots were fired?
I would say about 6 or 8.
Okay, 6 or 8. And do you know after the fact that any of the shots hit the house?
Yeah, they all hit the house.
Okay. And were you struck at all?
No.
Okay.
Thankfully.
Now, was Ms. Reed present when this happened?
Yes.
Okay, do you know where she was when the shooting started?
She was standing in the doorway of the house.
All right. And what did she do when the shooting started?
Once the shots went off, I guess she ducked down and.
Objection as to guessing, Your Honor.
Objection sustained.
If you don't actually see what she did, I know it's probably a chaotic situation. You don't, just tell us only if you know exactly what she did.
I mean, once the shots went off, I was outside the house and she was.
But prior to the shots, you saw her, she was standing in the doorway.
Standing in the doorway.
Okay. And so what happens after the shots are fired?
The shots was fired and they hopped back in their car and sped off.
Okay. And what did you do after that?
I ran in the house and checked on my sister.
Okay. And was anyone injured in this shooting?
No. Broken glass.
And did you call the police?
Yes. Okay. I made a police report.
Now, you said you were behind a wall. Where about on the side of the house, right? There's a small brick wall, is that what you said?
No, so the brick wall is like in the front.
Okay.
It's like to enter the porch, you have to walk up the driveway and the stairs is it's like coming up on the side of the house.
Do you know if any of the shots hit the wall?
Yes.
Okay. Do you know how many of the shots hit the wall?
I think from report it was about 6.
Okay.
I would say 6, yeah.
And that's the wall that you were behind?
Yes.
Okay. No more questions this time.
No questions, Judge.
Okay, thank you. You may exit the courtroom, sir. Any further witnesses for the prosecution?
No further witnesses, Judge.
Is there a motion?
Yes, Your Honor.
Well, if you could just hold
Yeah.
on, we'll take the exit. Okay, Okay, is there a motion?
Yes, Your Honor, the people move to bind over on all charges and reserve argument.
Mr. Fritz?
Judge, we would ask the case be dismissed for insufficient evidence in relation to my client, Ms. Bledsoe. It's a pretty minimal record in terms of her involvement in this situation. It was simply a situation where she drove up in a vehicle. Two men, not her, got out of the vehicle. They did what they did without her consent or approval or even knowledge they were going to do that. We have nothing on the record at all as to supposedly her understanding or agreement or anything. And I think that's required if there's going to be an argument here about if she didn't directly do anything. You have to show that she aided and abetted. Simple the fact that people got out and did something on their own, because there's no showing she knew what was going to happen or gave no approval. They did what they did, and then they jumped in their car and left. So there's simply no showing that my client aided and abetted in any way whatsoever the actions of other people. Yeah. So for those reasons, Your Honor, we'd ask that you dismiss counts 1 through 5.
Mr. Blumers?
Your Honor, the defendant's being charged under theory of aiding and abetting, and I think the evidence here is that Ms. Bledsoe was the driver in what was essentially a drive-by shooting. She drove to the victim's house where he was expecting her because she had told him that she was coming for a child exchange. She shows up without the child, but with two men, each carrying a gun. They get out of the car, shoot up his house, get back into her car, and she drives them away. I think that's a pretty clear basis for an aiding and abetting theory in this case. So I believe the people have met their burden as to these charges.
They didn't testify that they got back in the car she was driving. The exact statement was, got back in their car instead of, no, does that mean there was a different car at the location? We don't know. So again, I don't think there's enough here for aiding and abetting. There's got to be a mental approval or agreement as to what they did. There certainly isn't any showing of that.
Well, as it relates to that last, the posture you take on that last piece of evidence with regards to what the individuals with the guns did, my takeaway was that they got back into the car that they came in. And your takeaway is obviously something different.
It's just my takeaway based on what he said. That's it.
I would like to reopen the proofs in that regard. If you could bring the witness back in for that limited purpose, he obviously has got to still be here.
Yes, Judge, and I would say that my understanding was there was not a second car waiting for them when they got into that. They got back into the car that they came in. That was what I understood the testimony to be, but I'm happy to get into that specific.
I'd object to reopening. I didn't do any cross-examination.
Okay, and so your argument, Mr. Bloomers, would be?
Well, my argument was, from the people's position, the testimony was clear that he said they got back in the
Wait,
car.
no, I'm sorry. Yeah, you can bring them up. And I'm sorry. I ain't prepared to make it my decision because I took away what I took away from the testimony, and this is a probable cause examination. There is a question of fact. My takeaway from the testimony that the witness provided was that the individuals that were toting guns, that had fired guns at the house and at Mr. Stokes, as well as Ms. Reed, who was in the doorway immediately prior to the shots ringing out, was that they got back into the car that they came. That was my takeaway. Now, that verbiage was not used, but that was my takeaway from the testimony. So there is no need necessarily to reopen the proofs. It's a question of fact as to what involvement the defendant in this case had. But the testimony, as it has been elicited by the prosecutor, is that she drove them, was the driver, drove those individuals to the house, and with the expectation in the mind of Mr. Stokes that the child was coming with the defendant. The child was not with the defendant, but two men were. Two men got out of that car, two men were toting guns, two men fired those guns at the direction of the house, at the direction of Mr. Stokes and Miss Reed, who was standing in the doorway, some 6 to 8 shots. I am satisfied that the prosecutor has established that there is a question of fact that exists here as it relates to counts 1 through count 5. Count 5 is the misdemeanor, really count 1 through count 4. And the misdemeanor is going to travel along with the efficient administration of justice to be heard at the higher court level. But I'm satisfied that the prosecution has met their burden here. The matter will be bound over as charged with an AOI date of August 12th. Is that right? 19th, August 19th, I'm sorry.
Thank you, Honor.
Thank you.
Thank you, Judge.
Okay, Mr. Salem is here.
Good seeing you, Your Honor.
Again.
Again, 2 days in a row, my pleasure. David, okay, that's you.
Calling parties on Oldham, case number 2155129. The people of the state of Michigan versus Tammy Maria Oldham. The defendant is charged with count 1, home invasion, 1st degree. Count 2, assault with a dangerous weapon, felonious assault. Count 3, assault or assault and battery. Habitual offender, second offense notice. This is scheduled for a preliminary exam.
Thank you, ma'am. Appearances, please.
Good morning, Your Honor. Remind Cook on behalf of the people.
May it please this honorable court, Alvin Salem, 23797, on behalf of Ms. Oldham, who's present in court.
Thank you. Could you please state your name, ma'am? Thank you. We are proceeding to an exam.
Your Honor, at this time, the people are, I'm sorry.
Go ahead.
At this time, the people are not ready to proceed. Our complaining witness, Joy Phillips, was subpoenaed and notified to be in court today and has not done so.
Move to dismiss, Your Honor.
Thank you. It is currently 10:45. This matter was set for 10 a.m. and the complaining witness has failed to appear according to the prosecution. That being said, I am going to grant that motion to dismiss without prejudice. That means that trailer language after the word dismissal means that it is possible that the prosecution can reissue. If you have questions about that, please make sure you speak with your attorney and he will explain that to you in greater detail. Do you have on a GPS tether that needs to be removed?
No.
Okay. Counsel, Mr. Salem, I just need your signature on this order that I'm preparing as the moving party for the dismissal, and you'll be all set.
Thank you, Your Honor.
You're
Ms.
welcome.
Oldham, just wait for me on there.
Good job. He just like that. Okay. Fine. Mr. Officer, can you let Mr. Cripps know if he's out there, they're looking for him in 339?
I'm sorry.
Mr. Cripps, if he's in the hallway, can you ask him to go up to 339?
Okay.
Thank you. I'm gonna get copy in just a second.
All right.
You and I are, everyone's down there. The reservation.
Yeah.
Yeah.
I mean, physical.
No, thank God. Record section. Yeah, do you know him at all?
Yeah, I do. He used to be,
The clerk. He was the one clerk, wasn't he?
no, no, no.
Oh.
He was the Oakland County prosecutor in South.
Are we ready on Lenore?
No, but
I think we're waiting for the defendant to come up. I think he's on our way.
Oh, okay.
no, he went home. No, he drove
You know,
home.
Sabbath was taking over moments down there. Man. It's like,
I'm glad to see going go. I'm glad he decided.
well, he was tough.
Yeah, he was tough, man. Another good guy, you know?
Yep, yep. Thank you.
Good morning. How are you? Good, good, good.
He was already down.
What? Oh, okay. He probably went up there. I'm sure he knew.
Yeah, he did.
I'll just text him right quick. To go to 339?
Yes.
Okay.
Are you on Gracie?
Yeah, Grace is fine. I just got the officer.
Mr. Lenore.
Hello.
Mr. Lenore is here. They're not ready.
Yeah, we can hold.
Okay, I'm with you. Calling parties on Lenore. Case number 2156710, the people of the state of Michigan versus Simone Lenore. The defendant is charged with count 1, police officer fleeing third degree vehicle code. Count 2, assault with a dangerous weapon, felonious assault. Count 3, child abuse, 4th degree. Count 4, domestic violence, commission of a felony with a motor vehicle advisory. The defendant is also charged in case number 2156711, the people of the state of Michigan versus Simone Lenore. The defendant is charged with count 1, weapons, dangerous weapon using self-defense spray device. Count 2, domestic violence. These matters are scheduled for preliminary exam.
Thanks. Actually, hold on one moment, please. Mr. Williams, I just need one moment.
Yes, Judge.
Hi, Mary, this is Amy from the courtroom. Hey, there was a motion scheduled this morning for Julia Witt. Me? Okay, you emailed me. Okay, yeah, I don't. Right, so everything's all good now? Okay, that's fine. It was just still on the docket, and I don't remember like 20 minutes ago, let alone. So, okay, no problem. Thank you. All right. All right, bye. I don't know.
Okay, thank you for your indulgence. And can I have appearances, please, on Lenore?
Jacob Blues on behalf of the people.
Good morning, Your Honor. May it please this honorable court, Larry Pope on behalf of Ms. Simone Lenore, who is present and standing to my right and slightly to my rear. Ms. Lenore, state your name for the record, please.
Simone Lenore. Thank you. Okay, today is the date and time set for preliminary examination. It was set for 10:30. It's currently 10:54. Are we proceeding to an exam?
Your Honor, at this time, the people are unable to proceed on either file. Witnesses, complaining witness Kenneth Brett was subpoenaed to be here for the 10:30 exam. Without his presence, people are unable to go forward on the file ending 6711, on the file ending 6710. Officer Tucker was subpoenaed to be here. He is not present. Without his presence, people are unable to go forward on that other file.
Okay, Mr. Polk, is there a motion?
Judge, I would ask that these matters be dismissed and explain to my client it's a dismissal without prejudice, which means that the people are inclined and have additional information they could refile.
Okay, you understand that, ma'am?
Yes, ma'am.
Okay, so with that being said, I am going to grant that motion to dismiss on both of these files.
Oh, and I'm sorry, Judge, I should state that that is, on the 6711, that is for count 1, and on the 6710, that's for count 1 and 2.
Okay, yes, so on case number 210567110, count 1 and count 2 are going to be dismissed without prejudice. Count 3 and count 4 are going to be set for pretrial before Judge, is it
DB cases or?
It's child abuse, 4th degree and domestic violence.
Judge Garrett.
Okay, so what date can we get?
The 12th, August 12th at 9 a.m.
Which here?
Austin.
Austin. Okay.
August 12th, you said?
Yes.
At 9. And then, on case number 210567111, count 1 is going to be dismissed without prejudice. Count 2 is going to, like manner, be set for pretrial before Judge Garrett on August 12th, same date at 9 a.m. I'm preparing the orders of dismissal, and Mr. Polk, I'll need your signature on these forms as the moving party. And then we'll be all set. Was there anything further?
We need Mr. Slusky on that. So whenever Mr. Slusky is available. Anyone else out there, Grayson or Percival? Okay.
Your union staff have a great.
You too. Take care, Mr. Fuller.
Thank you. Take it easy. Everyone.
Mr. Slusky's.
So Miss Amira and her person, I believe, are here in person. Do you want her with me or? I'm not sure what we're doing.
Good morning.
Good morning.
Good morning.
Party's on drone?
Yes.
Case number 20.
Good morning. Good morning to you. On the device entitled Kiara's iPhone, you have entered into my Zoom courtroom. So I do have an expectation that you're going to wear clothes in the courtroom. I have an expectation, yes. Hello. I have an expectation that you would wear clothes. So since we seem to be having a little bit of a disconnect, I'm going to remove you.
Okay. Calling case number 2061800, the people of the state of Michigan versus Tina Jennifer Jerome. The defendant is charged with count 1, license, documents, plate forgery. Count 2, identity theft. Count 3, operating license suspended, revoked, denied, second or subsequent offense notice. Count 4, motor vehicle operation without security. This matter is scheduled for a probable cause conference.
Thank you, ma'am. Appearances, please.
Good morning, Your Honor. Jacob Slusky on behalf of the people, P83677.
Good morning.
Good morning, Your Honor. Catherine O'Mara, P53823, on behalf of Ms. Drone.
Please state your name.
Tina Drone.
Thank you. All right, today is the date and time set for a preliminary examination.
A probable cause.
Oh, I was gonna say, I don't see it on the docket as an exam.
No, we had changed it back to a PCC because Ms. Drone had intended to accept the people's offer and hopefully figure out how to use Zoom, but she never was able to do that, so we just sent it in person so she could come and accept the people's offer in person.
Okay, Mr. Slusky, the offer?
Yes, Your Honor. So the people have agreed or offered at least to dismiss count 2, identity theft, and also dismiss count 4, motor vehicle operating without security. We also are offering to reduce count 1 from license plate forgery down to a misdemeanor, unlawful use of a license plate, which is MCL 257.256. We're also reducing the driving while license suspended to no operator's license on person, which is 257.311, both of which are 90-day misdemeanors. The sentence is to be determined by the sentencing judge, and diversion or delayed sentencing is not available.
Okay, is that your understanding, Ms. O'Mara?
Yes, Your Honor, although we would ask for immediate sentencing if it's available.
It's not, because I don't have jurisdiction over it. Once the plea is accepted, it would go before the appropriate judge for sentencing. Would that be Judge Bryant?
Yes.
Okay. So with that being said, Ms. Drone, is that your understanding of the negotiation?
Is that your understanding that you complete the unlawful use of a license plate and no operator? Yes, ma'am.
Okay, so I need to understand if you completely understand the offer that's being made and what you are planning to do here today. So do you understand the allegations against you?
Yes.
Do you understand that you have a right to an attorney? If you couldn't afford one, one could be appointed to you.
Yes.
Do you understand that you have a right to a trial?
Yes.
Do you understand that if this matter proceeded to a trial, that you could have your attorney cross-examine witnesses presented by the prosecution? You could even have your attorney subpoena individuals to appear on your behalf and testify on your behalf. And then you could even testify on your own behalf if you wanted to.
Yes.
Do you understand that if you were to plead guilty pursuant to this negotiation, that that would have the effect of giving up your right to a trial? Do you understand that?
Yes.
So you can't a few months later or a year from now say, wait, I don't want this deal anymore. Once the plea has been accepted by the court, you give up your right to a trial. You understand?
Yes.
Okay. Has anyone promised you anything to get you to give up your right to a trial?
No.
Has anyone threatened you in any way?
No.
Are you pleading guilty to the 2 offenses that Mr. Prosecutor articulated on the record? Are you pleading guilty to those because you are guilty?
Yes.
Thank you. So you understand that with the fullness of the negotiation here, that there will be, at the conclusion of whatever sentence happens on the date that you get to return to the court for sentencing, there will be no dismissal at the conclusion of this matter. Do you understand that? No, what's typically referred to as delayed sentencing or diversion, which means the matter would ultimately be dismissed. That's not being offered here. Do you understand that?
Yes.
Okay. Do you understand that even though I would be accepting your plea, that there would be an entirely different judge that would sentence you?
Yes.
And you would be given a date before you leave here today for which to appear, I'm assuming virtually. You understand that?
Yes.
And in between today's date and that date, you will have to avail yourself to a pre-sentence investigation, commonly called a PSI. And I'm assuming that would also be done virtually. You understand that?
Yes.
And it's important for you to understand that you have to avail yourself to that interview before your sentencing date. In the event you go to the sentencing date and you have not had that interview, you will not be sentenced. Do you understand that?
Yes.
And based on the outcome of the pre-sentence investigation, the probation department will generate a report on how they feel you would be best served with sentencing. That recommendation goes to the judge, and she'll have an opportunity to read it before sentencing, and you will also have an opportunity to review it with your attorney prior to sentencing. Do you understand that?
Yes.
And if there's anything that you feel that was said in error or anything you want to highlight that isn't on there, you certainly will have an opportunity to do so before sentence is imposed. Do you understand that?
Yes.
Do you also understand that the sentencing judge will have discretion to impose anything that she feels is appropriate? For instance, if the pre-sentence report seems to reveal that you have a drug problem, the sentencing judge can order some level of substance abuse counseling. Do you understand that?
Yes.
Okay. That's just, I'm using that as an example. I'm not suggesting that that is the case here. But the sentencing judge will have discretion to place you on probation for whatever period of time she feels is appropriate. And if you fail to abide by whatever terms are set forth, which could be as simple as don't pick up anything new, or it could be more involved. But if you fail to abide by the terms, then the sentencing judge has the ability to impose further consequences. Do you understand that?
Yes.
She also has the ability to impose a fine as well as costs. Do you understand that?
Yes.
Okay. Do you have any questions for me before we move forward? I need an audible answer.
No.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Mr. Slusky.
Thank you, Your Honor. Good morning, Ms. Drone. I have a couple questions to ask you. So were you driving a motor vehicle in Wayne County, Detroit on November 10th of 2020?
Yes. Yes.
And was that vehicle a Toyota Camry?
It was a yellow car, yeah, a Camry.
Okay. And that vehicle that you were driving, did it display a license plate?
Yes, it had the paper plate.
And did the paper plate belong to that Toyota Camry?
No, I had bought the paper plate for someone.
So that paper plate belonged to a different vehicle?
No, it was just the paper. It was coming to my car.
A different vehicle than the Camry.
Did the paper plate in fact belong to a 2020 Ram?
You don't know the car that it belonged to, but it wasn't to your car.
No.
Fair enough. Also, did you have a driver's license on you at that time that you were pulled over?
No, I just had my ID. I didn't have license.
Okay, people are satisfied.
Thank you. The court is likewise satisfied. I will accept your pleas to count 1, unlawful use of a license plate, misdemeanor. Count 3, no operator's license on person, both 90-day misdemeanors. Counts 2 and 4 are going to be dismissed by the prosecutor's motion. Mr. Slusky, do I have permission to sign your name to the order of dismissal?
You do, Your Honor.
And sentencing date will be for the misdemeanors.
September 9th at 9 a.m. in front of Judge Bryant.
Okay, is there anything further?
Nothing further, Your Honor. Thank you very much.
Thank you.
Can I just confirm that sentencing date was 9/9?
Yes, sir.
Thank you.
9/9 at 9.
Your phone number, just so I can give the probation department so they can.
All right, have a good day, everybody.
You too.
Thank you, you too.
Thank you.
Party on receiver.
Can you make that for just a second, Judge? And this is Percival. Is that right, Percival? Calling parties on Percival, case number 2157389. The people of the state of Michigan versus Leon Gary Percival. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, assault or assault and battery. Habitual offender, third offense notice. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Good morning, Your Honor. Jeanette Williams White on behalf of Mr. Leon Percival, who is present.
Thank you. Could you provide your P number for me?
P 61864.
Thank you. Could you state your name, sir?
Leon Percival.
Thank you. Today being the date and time set for preliminary examination, are we proceeding to an exam?
Your Honor, at this time, the complaining witness, Amber Osley, is not present in the courthouse. She was subpoenaed to be here for an 11 a.m. exam. Without her present participation, people are unable to go forward as to count 1.
Is there a motion?
Thank you, Your Honor. We motion that this matter be dismissed.
Thank you. This is an examination that was set for 11 a.m. It's currently 11:15 by the court's clock. And with those representations being made, I am going to grant that motion to dismiss. The matter is hereby dismissed without prejudice, which means that trailer language after the word dismissal means that it is possible that the prosecution can reissue on this matter. If you have questions about that concept, please make sure that you talk to your attorney and she will explain it to you in greater detail, okay? Do you have on a GPS tether that needs to be removed?
Yeah.
Okay, I'm going to include that language on the order of dismissal that the GPS tether shall be removed forthright. And you'll get your own copy to take with you to the tether unit so that there's no confusion. We will also notify them via email this morning that the tether should be removed, okay?
Thank you, Your Honor.
You're welcome.
I'm sorry, Judge. There is a count 2 that is.
Oh, there is?
Yeah.
Yes, there's an assault and battery misdemeanor that follows the felony. So I am going to dismiss count 1. As that is the matter for which this court has jurisdiction. Count 2, the assault and battery is going to be set for a pretrial on August 12th. Should we say, or should we set a new date?
No, August 12th is good.
August 12th at 9 a.m. before Judge, it's an assault and battery, would that go before Judge Gary or?
Do you know?
Well, I don't know off the top of my head.
It might go before Judge
Bryant, I believe. If it's not a DV, straight up DV, then it will go in front of Judge Bryant.
It's under the DV unit here, but.
Yeah, I don't, it should have been charged as a DV, but it wasn't. Like, I'm looking from what I see, but it was charged as an AV, so.
I will put it, do Judge Bryant, but I will call and confirm. If it's a different judge, I'll call you and let you know.
It's a misdemeanor?
Yeah,
It's a
I
misdemeanor.
don't do misdemeanor.
Oh, okay, well,
And there will need to be a new court-appointed attorney.
then the misdemeanors office will, let me just call it, sir.
Yeah, give us just a moment, we're clicking that out right now.
Since someone's gonna know.
While she's checking into that, Mr. Bloomers, I had already pivoted to Mr. Percival to inquire about GPS tether. Are you objecting to any amendment to bond, given that?
No, given that the complaining witness did not appear today, the people would not object to the tether being removed.
Okay.
Obviously, no contact order should say.
Okay, do you understand that? I am going to continue with the removal of the GPS tether. However, the no contact provision that was put in place at your arraignment is still going to remain. So you cannot have any contact with Amber Osley. You understand? Not directly or indirectly. And what did we find out?
Judge Garrett, as long as it's a DD case and they're companions or that sort, then it will go to Judge Garrett.
Okay, so August 12th?
Yes.
Okay. So I would imagine also, can we tee it up so that he has a new court-appointed attorney that she can't take? No?
The misdemeanor defender's office does that.
Oh, okay, they'll be
Since
there.
it's criminal misdemeanor.
Yes, okay,
They'll
thank
be
you.
there for that.
All right, so you will have counsel. It will not be counsel that you have today, but there will be someone there.
So somebody, how would I, can I get in contact with them?
When I don't know that they can get in contact in advance.
Yeah, I'm not sure how that works.
When you get your notice to, I don't want to speak out of turn, Tammy, they will send notice, or is this his notification?
I believe this is his notification, but I'm not sure how
They must, because
Yeah.
there has to be some instruction as to who
As
to
to-
call or what Zoom number to
Right.
call. When you get that information, there may be accompanying information about how to get in touch in advance of the court date. But if not, just make sure you show up in the virtual courtroom on August 12th, and there will be someone there that you can go into a breakout room with and to discuss the matter. Okay? I am again gonna remove that GPS tether as the prosecution has indicated no objection to that, given that the complaining witness failed to appear here today.
Yeah, case number. Yeah, case number.
Okay, we're all set.
Thank you.
Oh, I just need your signature, Madam Defense.
I need your, in order for me to even tell you anything, I need your case number or, you go counsel. Or something I can reference. Hello? Yeah, I'm thinking they probably get a list ahead of time.
Okay, we're back on the record.
Calling parties on Pearson, case number 2062322. The people of the state of Michigan versus James Pearson. The defendant is charged with count 1, arson, preparation to burn a dwelling. Count 2, home invasion, first degree. Count 3, domestic violence. Count 4, malicious destruction of building, less than $200. Habitual offender, second offense notice. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Jacob Blugers on behalf of the people.
And good morning, Your Honor, Sarah Kraus, P81830, appearing on behalf of Mr. Pearson. I am standing in for the attorney of record, Gabby Silver.
Thank you. Could you please state your name, sir?
James Pearson.
Thank you. Okay, today is the date and time set for preliminary examination. Are we proceeding to an exam?
Your Honor, at this time, the complaining witness, Sandia Smith, is not present in the courthouse. She was subpoenaed to be here for 11:30 preliminary exam. Without her present participation, people are unable to go forward as to counts 1 and 2.
Madam Defense, is there a motion?
Yes, Your Honor, I would move to dismiss.
Okay, so that would pertain to counts 1 and 2, the felonies. Counts 3 and 4, the remaining misdemeanors, would be set for pretrial before Judge Garrett. And the matter is going to be dismissed without prejudice, again, as it relates to the felonies. And what that trailer language after the word dismissal, without prejudice, what that means is that it is possible that the prosecutor can reissue. If you have questions about the fullness of that concept, please make sure you speak to Ms. Kraus, and she will explain it to you in greater detail. Okay? Pretrial will be what, August 12th?
The 12th at 9
August 12th
a.m.
at 9 a.m. before, again, Judge Garrett, you should receive some notification as to how to appear. Likely, I'm imagining it will be virtually. So please make sure you receive that information. Will you be representing him at that hearing?
I don't believe so, Your Honor. We were assigned to Mr. Pearson's case. I would also like to indicate for the court that Mr. Pearson is on a GPS tether. I am asking for that to be removed.
Mr. Blowers?
Given that the complaining witness did not present herself today for the 2 felony counts, the people would agree to removing the tether so long as that no contact order stays in place.
Okay, do you understand that, sir?
Yes.
So I will grant that request to remove the GPS tether, but please make sure you abide by the no contact provision. Is your mask broken?
Yes.
Oh, okay. We would have given you a new one, but you're already done almost. It's okay. Make sure you abide by the no contact provision, which includes not only direct contact, but there shall be no indirect contact, no form of social media outreach, texting, letters, phone calls. Even if the complaining witness comes to you, you are not then permitted to engage with the complaining witness. You understand? Okay. Anything further?
No, Your Honor.
All right, we're all set. We are going to notify the tether unit from our angle by way of email, but it's a good idea for you to have your own copy of this order that I'm printing out, that you should have that tether removed, okay?
Okay.
All right.
We have to get out of the building. Here.
Ms. Kraus, I do need your signature.
Yes, Judge.
Okay, and let's recall, is Ms. Jones, recall that matter.
No problem. Recalling case number 21057389, people of the state of Michigan versus Leon Gary Percival.
Oh, yeah, I have it, don't I?
Oh, I called the wrong one. You have it. So
This is a recall of people versus Emmanuel. Although this is spelled wrong. What is your client's name? Is it Emmanuel or
It's Emmanuel. He has a pretty fancy cursive writing, so I think that
They spelled it on the complaint, Emmanuel.
There is an AKA, so I think maybe it must be in the system both ways.
I see. Last name is Grayson. This is 210575150. Today is the date and time set for preliminary examination in this matter, and it is now 11:33. This matter was set for an exam at 11 o'clock. Is that true?
Yes, Your Honor.
11 o'clock. And have we received any phone calls from Mr. Grayson?
No, no calls.
Wait, can you hold 1 second, Ms. Jones? I'm gonna see if this iPhone caller is perhaps, no. Does that look like your,
Mr. Grayson?
Yes.
Mr. Grayson, what are you doing? You're not in the right location.
I know I was in the wrong courtroom.
No, you're supposed to be physically here with us.
Oh, I'm supposed to come to court?
Yeah, like physically in the building.
Well, you know, y'all never sent out no mail to my address.
Ah, do you have witnesses?
Yes, Your Honor, the witnesses are actually present in the courtroom right here. People are ready to proceed.
How far are you away?
I'm not far.
Okay, what does that mean? Because your witnesses are here. I don't know if you can see beyond the prosecutor. They're here in the courtroom, so this isn't a matter where the situation would be dismissed because of officers not showing. Did you want to maybe telephone and find out how you want to proceed?
Do you want me to come down there?
I do, but we do a hard stop at 12:30 here. We've got a homicide that starts at 1:30. So if not far means you can get here like in 10 minutes, great.
It's gonna be like probably like 15 to 10, like around there, 15 minutes. I probably can get there 10, but I don't want to promise it. I come and I'll make it, but I'm coming straight to you if you want me to come.
We'll see you in a second. We're gonna see you in a second then.
Okay, here I come.
All right, thanks, bye.
Okay, I'm sorry.
morning. Could you please state your full name and spell your first and last name?
Yes, my name is William Timmer. You spell it WILLIAM. Last name Timmer, TEAMER.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give us the truth, the whole truth, and nothing but the truth? Thank you, sir. You can have a seat over here in this witness chair, so if you swing that half gate towards you and watch your step as you come up. Mr. Prosecutor, when he's settled, you may proceed.
Good morning, Officer Peter.
Good morning.
Could you please state your full name for the record?
William Timmer.
And Officer Tima, where are you currently employed?
Detroit Police Department, 8th Precinct.
And how long have you been employed there?
For now, about a year and 8 months.
Okay. And were you employed as a police officer with the Detroit Police Department on April 10th, 2021?
I was.
And were you on duty on that day?
I was.
Okay. And on that day when you were on duty, were you called to the address of 19132 Avon Street?
Yes.
Is that in the city of Detroit, County of Wayne?
Yep.
Okay. And do you recall what was the nature of that call?
It was domestic violence, assault and battery.
Okay. And how were you dressed on that day?
I was wearing Class B uniform.
Okay. Could you describe what that is?
So it's pretty much what I have on now.
Okay. Is it?
So use the uniform vest, the uniform pants.
Okay.
Dress shoes.
And is it clearly marked as police, that you are police? Okay. So do you recall about what time that you got that call?
If I recall, I believe it was around 2 a.m.
Okay.
I'm not sure for certain.
Okay. And did you arrive at that address on Avon?
I did.
Were you alone or with a partner?
I was with the partner.
And what's your partner's name?
His name is Christopher Davis.
Okay.
Excuse me 1 second. I think I would like, for the record, to reflect the fullness. We are here in court. We can obviously see when the officer says I'm wearing what I'm wearing now, but for the record, you're wearing a uniform, typically what's referred to as full uniform. Is that correct?
Yes, ma'am.
And do you have patches on either side of your arms?
Yes, ma'am.
And what else?
Patches, and then you also have a stitchable badge.
Repeat that for me. You just said.
You also have a stitchable badge.
On the shirt, on the face of the shirt.
Yes, ma'am.
Okay, thank you.
And was your partner dressed in the same uniform?
Yes, sir.
Okay. So I believe you just testified you did arrive at that address of 19132 Avon?
Yes.
Okay. What happened when you got there?
That's when I got there. I observed the victim, Ms. Simpson, running out of the house after Mr. Grayson.
Okay.
She pretty much said, you need to stop him. He's drunk, he's intoxicated, he's just choking, he just punched me.
Objection. What's the objection? To the hearsay being placed on record. Objection sustained.
Okay. Well, I am going to be asking some questions, and I will try to keep it limited, but for our purposes here today, we're only dealing with the R&O, the count one, not the misdemeanors, and so anything, there may be times when some level of statement from someone which explains why the officer acted as they did would only be used for that purpose and not for the truth of the matter asserted, because the truth content of whatever the allegations are don't really matter in terms of how the officer acted when they received those allegations.
Okay, so are you asking for the record not to be stricken and to continue with what the officer was attempting to answer, which included statements from the female he observed running out of the location?
Yes, Judge.
Your response?
Your Honor, that what was stated goes well beyond what his investigation would have, or what he observed, and what he did next. His statements go well beyond that, and it's prejudicial.
Okay, well, let me just ask this, Mr. Prosecutor, if you could, from the certainly any observations that the officer made when he approached can be testified to, but if you can just, in lieu of him stating what the female individual said, if you could just ask him what he did in response to those statements that were made to him by this female that was running out of the location.
Okay.
So, I believe, now the individual, the female you saw, was that Jasmine Simmons?
Yes, sir.
Okay. And you stated that, she was screaming to you about the defendant, Mr. Grayson, is that correct?
Yes, sir.
Okay. Did you see anyone besides Ms. Simmons?
No.
Not at that time?
No.
Okay. So upon hearing this and seeing this situation, what did you do next?
So I did check for signs of assault that took place on Ms. Simpson, and I did see a bruised face, and I did see bruising around her neck as if she was choked. And then from there, I checked on Mr. Grayson, and I did smell.
Okay, well, I'm gonna stop you there. So so there was, besides Ms. Simmons, there was another individual, you're saying?
It was just her, Mr. Grayson.
And Mr. Grayson, okay. So when you saw her come out running, where was Mr. Grayson?
Mr. Grayson, he was kind of in the front of the line. He was about to get in his car and take off.
Okay, and do you see Mr. Grayson here in the courtroom today?
Yes.
Okay, could you please point so the judge can see at this individual and then state something that they're wearing?
He's over there, the orange shirt and the blue mask.
Okay, please let the record reflect the witness identified the person of the defendant.
The record will so reflect.
Okay, so you said after observing these injuries on Ms. Simmons, you approached Mr. Grayson?
Yes.
Okay, so what did you do after approaching Mr. Grayson?
So I tried to ask Mr. Grayson pretty much what happened, and all he pretty much said is he didn't do nothing. That's pretty much all he said. And while he was talking, I did smell a hot odor of alcohol on his breath. So at that point, I probably caused to detain him to find out the situation further, to investigate further. So
okay, so after you determined that you had probable cause to detain him, what did you do next?
I asked him to put the baby down, and he refused to put the baby down. He said he's about to go, he's about to drive off. And I asked him multiple times to put the baby down, he refused. So at that time, to get him detained.
Okay, sorry, I'm just gonna pause you there. Now, you asked him to put the baby down multiple times. Is your partner present during this?
Yes.
Okay. Are there any other officers present at this point?
No.
Okay. So.
Sir, you can't do that.
You testified that you asked him multiple times to put the baby down and he refused.
Yeah.
So what happens next?
So I didn't want to go hands-on with him. So I did take out my taser and I kind of aimed it towards his, I believe his left leg, and then the side of the left side of his body. So none of the problems was on the baby. And then I asked him multiple times to put the baby down again as a compliance tactic. That's why I took out the taser, and he continued to refuse. So that's when I rehosted the taser and still asked him, he kept refusing. So that's when
Wait, say again?
I asked him again to put the baby down, and he just kept refusing to put the baby down. So that's when I took my left hand and kind of slid it between his hand to try to free the baby. My partner also helped with his left hand also to try to, help free the baby. And then we asked Miss Simpson to come down to try to grab the baby. And he still didn't put the baby down, so he started squeezing the baby hard and squeezing the baby harder to the point where the baby started crying. So at this point,
Okay, so I'm just gonna have you pause there. So at this point, you say you have an arm in his arm, and you say your partner as well?
Yes.
Okay, and you said that Miss Simmons came over too?
Yes.
Okay, and what was she doing?
She was trying to help also free the baby.
Okay.
So we did call for other units, they was delayed getting there. So we pretty much needed all the help we could get to try to free the baby and stop the baby from crying.
Okay. So, yeah, you said that the baby was crying because he was squeezing the baby hard. So what did you do next then?
So we kept trying to free the baby, and then he was able to finally let the baby go, and then Miss Simpson did grab the baby, and then I quickly put a handcuff on his left wrist, and then he had his right arm tucked under his body, so we couldn't handcuff the right hand. So after that, my partner did give her stripes to the, I believe, the right side of his body, and then he still didn't free his hand. So that's when I gave her close fit stripes to the rear of his back, and he still didn't let his hand go. And so I was just.
Okay, and do you recall about how many times you struck him?
5 times.
Okay, and so you said he still didn't let go. What happened next?
So that's when I took out my taser and kind of backed up and just yelled taser, taser, taser. And that's when he said okay, and then he put his hand behind his back.
Okay.
And he was able to successfully arrest him.
And, oh, I'm sorry, what was that last part?
Successfully arrest him.
Okay, and did you actually use the taser on Mr. Grayson?
I didn't.
Okay, so now I want to be clear going back. After you determined that you have probable cause to arrest Mr. Grayson, did you tell him that?
I can't recall. I believe I told him he was going to be detained at the time.
Okay.
But he still wasn't having that. So.
Okay. No more questions, Judge.
Cross-examination.
And were you wearing body-worn camera, Officer Teamer?
I was.
You were?
I was.
So there would be video?
Yes.
Okay, have you turned that over to the prosecutor's office yet?
One more time?
Have you turned that over to the prosecutor's office yet?
Not me personally, no.
Okay, and, did you, in this encounter with the family, did you inquire from the mother or from Mr. Grayson whether there were any custody orders regarding the child?
I didn't, no.
So you had no information what Mr. Grayson?
Object to relevance.
Awesome. So you stated, you testified that you ordered Mr. Grayson to release his child.
Yes.
You were telling him to release the child to the mother?
Yes.
On what basis, strike that? To your knowledge, did Mr. Grayson have a right to have his child?
At that time, he didn't know why he was intoxicated trying to drive off.
Okay. And when the child began to cry, that could also have been because, this was a female child?
Yes.
Couldn't that also have been because of the struggle going on around her?
Objection.
I don't think so.
The objection is sustained and that answer is stricken.
Your Honor, okay, was it your assumption that the reason the child was crying?
Wait, I'm sorry, ask the question again?
Wasn't it just your assumption of the reason the child was crying?
One more time?
You made an assumption as to why the child was crying?
Yes.
I'm sorry?
Did he answer your question?
Yes.
Oh.
Yes. And she was in the middle of a struggle between two officers and her father.
Yes, ma'am.
Okay, and you did not observe any injuries to the child?
No.
And you didn't do any type of breathalyzer to determine Mr. Grayson's body blood alcohol content or anything of that nature?
No.
I have no further questions at this point.
Thank you. Any redirect?
No redirect.
Thank you, officer. You may exit the courtroom. Okay, any further witnesses for the prosecution?
No further witnesses, Judge.
Madam Defense?
We have no witnesses, Your Honor. Is there a motion?
None of the people moving mine over. Count one.
Madam Defense, your response?
Your Honor, I would ask that the court not find over to count one.
the police didn't have any, basis to determine that Mr. Grayson had no right to, leave with his child. They didn't determine that, the mother had any type of custody order that would have given her superior right to the child. The child didn't start crying, according to the testimony, until the officers began trying to separate her from her father. Your Honor, I would ask the court not to bind over.
Your Honor, the police acted because they saw Ms. Simmons, Jasmine Simmons, come out of the house saying that she had been assaulted by the defendant. They observed injuries on her, and it was based on that probable cause that they made the determination to detain him. It was at that point that they needed him to release the child. It was not a custody thing. It was purely, he can't be in handcuffs and also hold the child. He refused to relinquish that child to the child's mother at that point, and that turned into a further, physical altercation.
Thank you. So I've had an opportunity to listen to Officer Teamer's testimony, just as the two of you have, as I'm speaking to the prosecution and defense, as well as the defendant here. The officer testified rather succinctly as to what happened on April 10th, 2021, and that he responded to this police run, arrived at the location in the city of Detroit, and while he was in full uniform, as well as his partner, he observed upon arriving at that location, observed a female that came running out of the house and was screaming. The statements for which we did not get into, as that is really more so going towards the misdemeanor, which is not necessarily a party to this hearing here today on the felony. But yet, based on the representations that that woman made that was exiting the house, running out of the house and screaming, the officer then noticed, and he testified again very succinctly as it relates to the physical injury, he noticed about the woman. And there was no one else there but the defendant, Mr. Grayson, who the officer successfully identified here in court today without any hesitation. And in an effort to detain him, the officer would have been remiss not to, given what he had observed taking place with his own eyes. And the defendant, according to Officer Teamer, refused to cooperate by not freeing his hand, and apparently was holding a baby at the time. And the officer testified very succinctly, again, as it relates to the request that was made to put the baby down so that he could detain the defendant. And the defendant refused to do so. The officer made an attempt to approach the defendant's left side with his taser out. Again, no success. The defendant would not put the baby down. The officer tried to free the baby himself from the defendant's grip. Still, the defendant would not put the baby down. Then he testified that the defendant was squeezing the baby, and at that point is when the officer testified that the baby started to cry. Now, certainly this was an excited situation. Babies cry at many things. It could have been all of the excitement, but according to the testimony, Officer Teamer associated the baby's crying at that time with the defendant holding on tight. The terminology he used was squeezing the baby. And he said squeezing the baby so hard that the baby started crying. The officer continued to attempt to free the baby, and the Miss Simmons, Jasmine Simmons, who we didn't hear from today, did eventually come to that general vicinity and assisted, and once the baby was free, the baby was handed over to Miss Simmons. The officer had testified that even after that, the defendant refused to free his hand so that the officer could handcuff Mr. Grayson. And that, in fact, he had to strike the defendant. I believe he said his partner did, and then he also struck the defendant, Mr. Grayson, 5 times, I believe he said. And then, still no compliance, he yelled taser 3 times, took his taser out and yelled taser 3 times, and then the defendant finally complied. So certainly as it relates to count 1, which is all we're looking at here today, Mr. Grayson, is count 1, because that's the felony. That's the police officer assaulting, resisting, obstructing.
My baby has a crush.
Based on the totality of the circumstances, the court does find, whether there was a whimper from the baby or not, there has been more than enough testimony that has been articulated on the record as it relates to the defendant's failure to comply and in fact his resistance in cooperating with Officer Teamer, who was responding to this very excited situation, this police run wherein there were certain indicia that led him to believe that the defendant needed to be detained. So the officer would have been remiss had he just turned away and walked down the street and not addressed the situation. And with defendant's failure to comply and the testimony as articulated by the officer, the court is satisfied that probable cause has been met here. The matter is going to be bound over to the circuit court for further proceedings on count 1, count 2, which is the misdemeanor, and count 3, which is another misdemeanor, are going to travel along for the efficient administration of justice. And the arraignment on information date is going to be August 19th.
Thank you, Your Honor.
And the court is going to stand in recess until 1:30.
All right, you can have a seat in the chair right there.
Calling parties on Sankey, case number 2158293. The people of the state of Michigan versus Mikhail Sankey. The defendant is charged with count 1, homicide, murder, first degree, premeditated. Count 2, weapons, firearms, discharged in or at a building causing death. Count 3 and 4, weapons, felony, firearm. Habitual offender, second offense notice. This is scheduled for a preliminary exam.
Thank you. Appearance, please.
Good afternoon, Your Honor. Richard Nelson Jr. on behalf of the people, P 78306.
Good afternoon.
And good afternoon, Your Honor. Coral Watt, appearing on behalf of Mr. Sankey.
Good afternoon, Ms. Watt. And could you state your name, sir?
Mikhail Sankey.
Thank you. All right. Are there any preliminary matters to commence with?
Your Honor, may Ms. Watt and I approach?
Sure.
Thank you.
We are back on the record. Are there any preliminary matters or stipulations that we should address?
Yes, Your Honor, I guess there are two preliminary matters for the people. First of all, I would ask for a mutual order of sequestration. COVID has kind of already done that here in the courtroom, but we are broadcasting on YouTube. So I know the court has a speech that it will give, so I would ask for that to happen. And with the exception of my acting officer in charge, Detective Emily James.
Any objection to that officer being here?
No, Your Honor.
Okay, so sequestration will be granted, and it is true the courtroom is void of any spectators due to COVID restrictions that are still in place. So the only people that are inside of the courtroom are those connected to the case and or working the courtroom. The second tier of sequestration is the Zoom gallery, which I've already restricted. The only individuals here now are those working the courtroom. I don't know if you need to were you looking down at your phone because you want me to let you in? I did create a waiting room. Do you have the need for share screen at all?
I will have, yes, I will need to get my computer set up. I will be playing a brief video, so I will do that right now.
All right, I will enable that feature. And when you attempt to log in, then I will let you in. So if you hear the chime indicating someone has entered the Zoom gallery, it will be because I've let them in, and they're typically an attorney checking on a different case, or Mr. Prosecutor when he logs in. So the Zoom gallery has been restricted. The third tier to sequestration is that this is live streaming on YouTube. So if there's anyone watching the live stream that should not be watching the live stream because you're either a witness or a potential witness, now would be the time to stop from watching the proceedings to maintain the integrity of this process, because it may preclude you from testifying in the future if you were to watch the proceedings. So with that being said, anything further? Anything further from the prosecution?
Yes, Your Honor. The people would also seek to admit at this time People's Exhibit number 3. This is an 11-page document. I have talked with the defense counsel about this. I do believe we have a stipulation for exam purposes only. This is a report prepared by the Office of the Wayne County Medical Examiner. So if there's no argument to its objection for exam purposes, I'll read some of the pertinent parts.
Your Honor, I would allow introduction of this evidence for exam purposes only and reserve my right to have an independent expert conduct an independent examination at a later date.
Thank you. Thank you. The proposed exhibit number 3 will be admitted as People's 3, and if you care to read in the cause and manner, you may do so now.
Yes, Your Honor. This is a report authored by Dr. Lokman Sung, Lokman, last name Sung, who is an assistant medical examiner for the Wayne County Medical Examiner's Office. It is dated July 26, 2021, and it does list the cause of death as multiple gunshot wounds with complications and the manner of death as homicide. And it also speaks to the identification of the body by a family member, Miss Alicia Rodriguez. I'm sorry, Allysia Rodriguez, Rodriguez.
Thank you so much. Anything further?
That's all for the people's preliminary matters, other than I did receive a text just a moment ago. It appears that the Tecker cab company never showed up. I texted an address to the sergeant that is arranging this. So it sounds like we're taking another stab at getting a cab there. Okay. And as I get details, I'll share them with the court.
Perfect, thank you. Anything further from the defense?
Nothing, I'm sorry, nothing further, Your Honor.
Thank you. Okay, first witness.
The people will call Officer Rebecca.
Okay.
Thank you.
Before we get any further, there is an individual, I'm sorry, well, I don't think this is something that is extremely sensitive, so he can stay right there for now. Julio Ramos?
That is the, Julio Ramos is the decedent in this case, so I imagine that's probably a family member. I had passed along instructions for them to view on, so I'm not sure why somebody has logged into Zoom, but that is the complaining witness in this case.
Okay. If you are connected to audio, the device titled Julio Ramos, can you identify who you are and what your relationship is to this case? Okay, the device that is titled Julio Ramos. Can you please allow the video to appear and state what your name is and your relationship to the case? The device that's titled Julio Ramos. Can you please state your name and your relation to the case with your video rolling? One more time, the device that is titled Julio Ramos. If you could state your name and your relationship to the case. Okay, well.
I'm his son.
And your name?
Julio Ramos.
Any objection, Mr. Prosecutor?
No, Your Honor.
Mr. Ramos, can you please show your video? Are you alone in, it looks like you're in a vehicle. I hope you're not driving while you're.
No. I'm with my sisters.
Okay, any objection to what he has referred to as his sisters present? He's in a vehicle and he is not alone.
No objection from the people. We would not be planning on calling his sisters or Mr. Ramos. I believe that's the decedent's son.
That's what he said, yes. Julio Ramos, the decedent's son.
And I believe he lives out of state, so the people would not be calling him as a witness in any way.
Madam Defense.
Your Honor, based on the discovery that I've received, I don't believe that Julio Ramos is a witness or someone that would be in any way connected with this case, nor are his sisters.
Okay, so do you have an objection?
No, based on what I've received, no.
Okay, so sir, you are permitted to remain in the Zoom gallery. Please, if you would, keep your microphone muted. And also, if you could turn your video camera back off.
Yes, Your Honor.
And one last thing, if you can hear me, please make sure that you refrain from any outbursts of the proceedings.
Yes, Your Honor.
As that would obviously not be appropriate. So just keep your microphone muted and the video off. You'll still be able to hear us and see us, but if you could oblige in that regard, that would be great, okay?
Yes, Your Honor, thank you.
Thank you. Okay, your first witness, please.
People will call Officer Rebecca to the stand.
Okay. Sir, could you please state your full name and spell your first and last name, please?
Yes, ma'am. My first name is Alec, A-L-E-C, last name is Rebecca, R-E-B-E-C-C-A.
Could you please raise your right hand?
Yes, ma'am.
Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. If you could come this way, this little half gate will open up towards you. Watch your step coming up the steps, and please be seated. Mr. Prosecutor, your witness once he's settled.
Thank you. Say your name again for the record, please.
Officer Alec Rebecca.
And Officer Rebecca, what is, you said officer, what are you an officer of?
The Detroit Police Department.
And how long have you been so?
Two and a half years now.
And do you have any particular assignments with the Detroit Police Department?
I'm assigned to the 9th Precinct Patrol on Platoon 3.
Okay. And were you so assigned back in August 2020, specifically August 11th, 2020?
Yes.
And you said Detroit, that is Wayne County?
Yes.
Okay. So the afternoon of August 11th, 2020, were you working with a partner?
Yes, I was.
And did you go to any specific address that brings you to court today?
Yes, there's an address on Fairmount where we received a call for a shooting that night.
And so did you and your partner go there?
Yes, we did.
How were you dressed?
In full uniform.
How were you driving?
In a fully marked scout car.
Okay. And do you recall approximately what time you got there?
I want to say it was around midnight sometime. It was just close to our shift change.
Okay. And when you got there, did you go inside the house?
Yes, I did.
Were you invited in?
Yes, we were allowed in.
Do you know who invited you in?
I believe it was.
Yeah.
I can't remember her name. It was the victim in this case, Julio Ramos' girlfriend at the time.
So a female let you in?
Yes.
Who was in the house when you got there?
The female that let us in, and then I made contact with the victim in this case, Julio Ramos.
Wait,
Okay.
say that one more time.
Okay, we'll change it.
There was the female in the house who let us in, and then the victim who was inside the house, Julio.
Thank you.
Now, the woman that let you in, was she in a wheelchair?
If, to my recollection, there was also another female in there who was in a wheelchair, yes.
Okay,
You said there was another
There was
female?
another female, yes.
Okay, thank you.
so 2 females, 1 in a wheelchair, 1 not in a wheelchair.
Yes, sir.
Okay. And you said Julio Ramos was there.
Yes.
What was his condition when you found him?
When I approached inside, from what I remember, he was sitting inside on a bed in one of the front rooms, and he was breathing really heavy. He appeared to have been shot.
You said he appeared to be shot. What led you to that conclusion?
From my experience as a police officer, seeing shootings and seeing people being shot before, there are multiple wounds.
Okay. When you say multiple wounds, do you recall where those wounds were on his body?
There was a couple in his right arm, his chest, the stomach area. I ended up having to cut his shirt off with what I call the seatbelt cutter, and ended up getting blood sprayed on me at that point while trying to render aid.
And did you render aid?
Yes, I did.
And at any point, did EMS come?
Yes, I did.
Did you call EMS or did somebody else?
Normally, when a shooting comes out, EMS is automatically spawned to come to the location. As soon as we deem it safe, EMS will, make entry once they arrive.
Okay. So is it fair to say that within a few minutes, EMS was there?
Yes.
Okay. And did you turn over his treatment to EMS?
Yes.
What happened after that?
After that, EMS got him out of the house. They put him in the rig, and then, from my understanding, they went to the hospital. At that point, I obviously wasn't in sight of him or anything like that. I was still at the house after EMS left.
Okay. Did Mr. Ramos, was he conscious when you talked to him, or when you saw him?
Yes, he was.
Did he communicate with you at all?
Yes, he did.
Is there anything that he said to you that you recall?
When I asked him, because I've been to the house multiple times for other different reasons, I asked Julio, I was like, Julio, who shot you? And he said it was Mike.
And you said you've been to that house before?
Yes, I have.
How many times have you been to that house?
I couldn't give you an exact number, a couple of times. I know I've arrested people out of that house for various reasons.
Did you ever arrest Julio out of that house?
Not to my recollection, no.
Did you know who Michael was, or Mike was, when he said that?
I had never met Mike. I had never seen Mike. The only reason I knew who Mike was is because I'd been at that house previously, because...
Your Honor, I'm going to object, because I don't know where this line of questioning is going, and whether or not he's going to be talking about a separate incident or an incident that relates to this case.
Your response?
That's fine, Your Honor. I was just trying to establish his familiarity with the house, and I think we've done that. So I can move on.
Thank you.
And so you had never encountered Mike personally before that day? Was Mike there when you were there?
No.
No further questions, Your Honor.
Cross-examination.
Thank you, Your Honor. Good afternoon, Officer Rebecca. Do you recall what the victim looked like?
Yes, I do.
Okay, are you able to give a description of him?
Of the victim?
Yes.
Yes.
Okay, was he short or tall?
He was average height,
And what would you consider average height?
5'8", roughly.
So you believe he was short, 5'8"?
I would consider that average height. I wouldn't consider that short.
Okay, and how much did he weigh?
He was a rather large individual. I would say almost 300 pounds, if not more, maybe less. It's an approximation of weight.
Okay. And you've indicated that you were let in by a female.
Yes.
Is that correct? Other than the 2 females and Mr. Ramos that you've described, you've indicated there was no one else in the home.
Not to my
Fair to say?
recollection, no. Not to my recollection, no.
Okay. I have no further questions, Your Honor.
Can you redirect?
No, Your Honor.
Thank you. You may exit the courtroom, sir.
No.
We can make a record to, but, well,
Your Honor, with Officer Rebecca leaving, his partner, who was there that day also, she was subpoenaed and she is here. After talking with Ms. Lott, we're going to dismiss both of them. The other Officer Thomas, would be cumulative, but I just had her here as backup.
Okay, so.
I would agree, Your Honor, that her testimony would be cumulative.
Okay, thank you. So the officer that you mentioned, certainly the one that just testified and the one that's waiting in the hallway is permitted to exit the courthouse. If you have no further need for them.
With that, Your Honor, the people will call Officer Stephen Townsend to the stand.
Okay. Can you please state your full name and spell your first and last name, sir?
Stephen Townsend, TOWNSEND,
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give us the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Have a seat here. Mr. Prosecutor, once he is settled, you may proceed.
Thank you. And Your Honor, as we discussed, this is a little bit out of order with what I would normally be calling, but we did discuss that. And I am told that the other two civilian witnesses should be here hopefully shortly. I don't have an exact ETA at this moment in time.
Thank you.
Would you say your name again for the record, please?
Police Officer Stephen Townsend.
And you said you're a police officer with what force?
Detroit Police Department.
How long have you been so assigned to the Detroit Police Force?
This is my 13th year.
And back in August of 2020, did you have any specific assignment with the Detroit Police Force?
I did.
What was that assignment?
I was assigned to the non-fatal shooting team of the 9th Precinct.
Okay. And did you become involved with a case where Julio Ramos was a victim and Michael Sankey was a suspect?
Yes.
What was your level of involvement with that case?
I was the officer in charge of that case.
Okay. And at that time, it was a non-fatal shooting, is that correct?
This is correct.
Because Julio Ramos was still alive?
That's correct.
Okay. And at some point, Julio Ramos passed away?
Yes.
Are you still the officer in charge of the new case?
No, I'm not.
Okay. So I'm going to draw your attention back to August 12th, 2020. Did you have an opportunity to sit down and talk with Mr. Sankey?
I did.
Where was that? Where did that conversation take place?
The interrogation was conducted at the Detroit Detention Center.
So at the Detroit Detention Center, does that mean that he was in custody at that time?
Yes, it does.
Were you there when Mr. Sankey was arrested?
I was.
Where was he arrested?
He was arrested over on Jefferson and around St. Jean area.
Okay. And when Mr. Sankey was arrested, are you aware, did he have anything on him that was of interest to you regarding this case?
He did. He had a pistol in his pocket.
What kind of pistol was it, if you recall?
I don't recall.
Okay. Now, when you talked to Mr. Sankey at the Detroit Detention Center, and he was in custody, was he read his Miranda rights?
Yes, he was.
And those are the rights that everybody sees on a TV show like Law and Order or something like that, right?
That's correct.
Did you go over those with him?
I did.
Did he understand them?
I believe so.
Did he tell you that he didn't understand them?
No, he didn't tell me he didn't understand.
Okay. Now, and I'm going to back up here. When Mr. Sankey was taken into custody, roughly at the Jefferson and St. Jean area, which is over on the east side, Do you know where he was coming from?
He was coming from, I believe it was his place of employment, the car wash at Jefferson and Alter Road area.
How did Mr. Sankey appear to you when he was taken into custody?
What do you mean?
Was he lucid and aware, or did he appear to be on some sort of mind-altering substance of any kind?
No, he appeared normal to me.
Okay. And when you interviewed him in the Detroit Detention Center, how much time had elapsed from when he was first arrested to when you sat down to talk to him?
Maybe roughly an hour and a half to 2 hours.
In that hour and a half to 2 hours, did he, when you came back to sit down and talk with him, did he appear at the Detroit Detention Center? What was his state of mind to you? How did you perceive his state of mind?
I perceived him to be fully cognizant of what was going on. He spoke to me clearly and somewhat concisely and fairly direct. It was a short interrogation and it got right to the point.
Okay. Now when you went over the Miranda rights, was anything memorialized and put on paper?
Off the top of my head, I believe that he signed acknowledging that they acknowledged his rights and they understood them.
Your Honor, may I approach?
Yes.
Let the record reflect that I'm handing the witness People's Proposed Exhibit Number 1. Officer Townsend, what did I just hand you?
You handed me the constitutional rights certificate of notification form.
Okay. Is there handwriting on that page?
There is.
Is that your handwriting or someone else's?
There's my handwriting, and then there's a signature that I interpret to belong to Michael Sankey.
Okay. And speaking of Mr. Sankey, do you see him here in the courtroom today?
Well, there he is. Yes, I do.
And can you describe maybe an article of clothing that he's wearing?
Appears he's wearing a dark green shirt and a blue mask.
Your Honor, please let the record reflect that the witness has identified the defendant in this case, Michael Sankey.
The record will so reflect.
Thank you. And you said that there's a signature of Mr. Sankey on this page.
Yes.
Were you there when he signed it?
I was.
And at any point, did he tell you that he was not understanding of these rights that you had gone over with him?
No.
At any point, did he request a lawyer?
No.
Your Honor, at this time, I would I would turn over to defense counsel for voir dire as to voluntariness.
Defense.
Thank you. Good afternoon, Officer Townsend.
Good afternoon.
Now, you've indicated that you first came into contact with Mr. Townsend on Alter Road in Jefferson, in that area, correct?
No.
Where did you arrest Mr. Sankey?
I believe it was in the area of Jefferson in St. Jean, kind of close to the Chrysler plant.
Oh, okay. And it's your recollection that there's a car wash in that area?
There's a car wash at Alter in Jefferson is where Mr. Sankey was employed.
So is it your testimony that you approached Mr. Sankey near St. Jean in Jefferson? That's when you first approached him, is that correct?
That's when I had him stopped by a marked unit from the 5th precinct.
Okay, were you surveying Mr. Sankey?
I was made aware of where Mr. Sankey worked. I drove by, I observed him getting into his vehicle. I called for a marked unit and they arrived and that's where he was stopped.
Okay, and so you were present when were you present when he was stopped by the marked unit?
Yes.
Okay, and approximately what time was that?
Without referring to a report, it was in the daylight hours. It was maybe late morning, early afternoon. I'm not exactly sure.
Okay. And when that car picked Mr. Sankey up, do you know where he was transported? Did you follow the car?
No, he would have been taken to the Detroit Detention Center. for processing.
Okay, but you didn't follow the vehicle or observe the vehicle transporting Mr. Sankey. Would that be fair to say?
That is fair to say, yes.
Okay, so Mr. Sankey ends up at the Detroit Detention Center, correct? And at what point in time do you come into contact with Mr. Sankey at the Detroit Detention Center, and where?
Well, in the jail, the Detroit Detention Center. Excuse me. There's interview rooms.
Right, I am aware of that.
Okay.
Where did you come into contact with him?
Well, it would have been at building 500 initially. And the protocol is you walk across the yard, you ask for the person that you want, you take them, you put them in handcuffs, you walk them back across the yard and into the interview room.
And is that what you did?
That is what I did.
Okay. Did you have another officer that participated in the interrogation of Mr. Sankey, or were you by yourself?
I believe I was by myself.
So you walk across the yard, get Mr. Sankey, bring him back to the interview room, and that's where you begin to conduct your interrogation. Is that correct?
That is correct.
Okay, and you've indicated that you present a constitutional rights form to Mr. Sankey. Do you read that to him, or does he read it?
I read it to him, and point by point. In this case, I'm not sure if I remember if I asked him to read it or not, but he had an opportunity to. I do have marked on here that there's a box that indicates suspect is illiterate. And then explains to him, if he has any questions about the rights that I read to him. So.
Okay, so you were able to ascertain, or a box was checked, that Mr. Sankey is illiterate, and
Yes.
meaning he cannot read.
Correct.
And so is it your testimony that you then read the rights to him?
I did.
Okay. And then after you read the rights to him, I see some more handwriting on this form. And you've indicated some of it is your handwriting, some of it is Mr. Sankey's handwriting. What portion of it's probably easier to ask you, what portion of the form is Mr. Sankey's handwriting?
His signature.
Okay. So Mr. Sankey placed his signature on the form. Did Mr. Sankey date it and put the time, or is that your handwriting?
That's my handwriting.
And so would it be fair to say that the rest of the handwriting on this document is your handwriting?
That is correct.
Okay. And so after you read the rights to Mr. Sankey, does he ever at any point in time indicate to you that he wants to stop, or he wants a lawyer, or he doesn't want to talk to you anymore?
No.
And during your interrogation of Mr. Sankey, does he ever indicate that he is under the influence of any narcotics or substances that would affect his ability to understand, perceive, or communicate?
No.
And approximately how long did you go over this form? Strike that. Did Mr. Sankey ask you any questions about what was on this form that you've indicated he signed?
I don't recall.
Did Mr. Sankey indicate to you that he was in pain, or he needed to stop and use the restroom, or that he needed food or water or anything of that nature during the time that you interrogated him?
No.
You've testified that basically the only, or the sole memorialization of his statement is the video. So there's no written document.
There's no what?
Written document. Would that be fair to say?
Yes, that's fair to say.
Okay. I have no further questions of this witness, Your Honor.
Mr. Prosecutor?
Your Honor, based on my questions, the witness's testimony, and Ms. Watt's question, I would ask that we find, or that you find the Miranda rights were properly conveyed and that any subsequent statement was knowingly and intelligently and voluntarily given.
I'm satisfied with the foundation that's been laid. Ms. Watt, did you wish to make a record?
Just, Your Honor, that for exam purposes only, I have no objection at this time.
Certainly you may proceed, as I do find that the proper foundation has been laid with regards to these statements, provided there were statements that were made. We haven't gotten that far, were voluntarily made.
Thank you. And as Ms. Watt mentioned, there was no written memorialization. Was there a video that was preserved?
Yes.
And was that video placed on a disc?
Yes.
And was that disc part of the file that was submitted to the Wayne County Prosecutor's Office?
Yes.
Your Honor, at this time, I would move for the admission of People's Proposed Exhibit number 2, which is the disc that we have been talking about, which does have the 15-minute and 39-second interview on it.
Okay, before I pass to Madam Defense to find out what her response to that is, People's Exhibit number 1, which was the constitutional rights, I know I made a determination as to the proper foundation to proceed, but were you moving to admit that?
I thank you, Your Honor. I got ahead of myself. Yes, I would move for the admission of People's Proposed Exhibit number 1 as People's Exhibit number 1.
And given what the Madam Defense has previously stated on the record, I would assume that there's no objection for exam purposes?
No objection.
Okay, so People's Exhibit number 1 will be admitted as People's 1. People's Proposed Exhibit number 2, which is the disc of the interview.
Yes.
You're seeking for the admission of that at this time?
Yes.
Counsel?
I'm sorry, no objection for exam.
Okay, People's Proposed Exhibit number 2 will be admitted as People's 2.
Your Honor, from a technical standpoint, what I propose that I do right now, I had logged into Zoom a few minutes ago, but there was terrible feedback. In this courtroom, what I have done in the past, it's easy to play a video where there's no sound, but when there is sound, that triggers the feedback. What I've done in the past is go into one of the witness rooms and play the video. Rather than play the entire 15-minute and 39 seconds, I plan on just playing the first minute, the first 5 minutes and 2 seconds.
Madam Defense, any objection to restricted showing of the video?
Well, Your Honor, generally, since this is a record being made, I usually object and ask that, and this is a short one, so this isn't like an hour-long one. So I would just prefer the whole video.
Okay.
I'm fine with that.
Okay, and yes, you're right. There is tremendous feedback when you attempt to play it in. There is a way around that. I'm just not very tech savvy. Someone did it once or twice. You know how to do it, officer?
Yes, ma'am. He has to share his screen. Once you share your screen, you have to mute your personal device and then click on the icon that says allow audio.
Yeah, I think that's it. It's the allow audio after you do that bit. So let's try it.
It sounds like he's smarter than I, and if he will help me with.
I've never done it. I just heard the instructions being given.
Okay, well,
Let's try to do it.
absolutely.
Try to do that, and if that doesn't work, then yes, we'll just have your device taken to the hallway.
Okay, so what I'm gonna do is I'm gonna log back on to Zoom. That can take a moment.
And as soon as you log in, you should mute your device, right?
But click the allow audio first.
Oh,
And
okay.
then mute your device. So it's gonna go away once you log in.
Right, okay.
If this works, we're gonna need you to stay in here.
Right.
Every
You can
time.
never leave. I need to write down those instructions.
Yes.
A lot of pressure on you, officer.
I miss you too, Judge.
Your Honor, if this works, I propose we give him a raise.
I have with it. Who's signing the checks?
He can be a tag.
Right.
Okay, now I've got the option of join with video. It doesn't say anything about audio.
It should be there. You join with video, then it'll say, no, you get the option to allow audio.
No, maybe.
So join with audio and then.
Exactly. Join with audio.
Mute your personal device.
Sounds like Space Odyssey.
I'm muted. Your Honor, is there any feedback?
No.
All right. Thank you.
He's so smart. We need to write that down.
Very impressive, officer.
So you gotta do.
Okay, Your Honor, I have now shared my screen with the court. Officer Townsend, can you tell me, does this look familiar?
Yes,
And this is the interrogation that we've been talking about?
yes. I think I'm wearing the same shirt.
So you've identified your shirt, at least. Thank you. Here we go.
Now, I hear the audio coming from your device, not on the.
All right, I will try that again. I've muted my device. And we'll see if it transmits the audio as well. See, it's playing now, but with no audio.
Where's our tech savvy officer again?
I stay on mute, Judge.
Let's try the old fashioned way.
Go to your room.
Thank you, yes. Thank you. Your Honor, can you hear me?
Yes, sir.
Okay, I'm going to press play now, and if you do not hear, well, first I'm going to rewind it. If you do not hear any audio on your end, please let me know.
Okay. Good to go. I think.
Michael, thank you for February 15th, 1960. All right. I don't have to answer any questions for you. Any statement I make or anything. Right attorney, or during the time I can't make any statement. I can't afford an attorney. One will be cost by the court prior to any questions. I can decide at any time to exercise my rights, answer any questions, or make any statement. And just sign this. This is here. I understand my rights. I have not been threatened or violated. So I agree to answer any questions. I do that. You sign right there.
No, yeah, I'm sorry, can someone, can you hear us, Mr. Prosecutor?
Yes, Your Honor.
Can you come join us? was hoping it was just me, but I can't, and maybe it is just me, but I cannot hear
I can't
very clearly.
So okay, it's not.
Can you mute your microphone?
One moment. Okay, I'm muted now.
Yeah, I don't know what it sounded like from where you were watching it, but I was picking up, for the most part, what was happening preliminarily, but then when he started to ask the first question, the first substantive question, I wasn't hearing all of the words. And I think that is not really fair or appropriate for this proceeding to not hear all of the words. So, I don't know, any suggestions? When you listen to it,
Yes.
is it a clearer version?
Yes. Ms. Watt, when you listened to it, did you have any issues?
You're talking about here?
No, like on your own.
No, on my own, I could hear.
Okay. So I guess what I can propose is, if it works for Your Honor, maybe being that the exhibit has already been placed into evidence, you can review that in camera and listen to it on your own.
Are the witnesses on their way? Because I can watch it right now. And then we could kind of have some progression. Why don't we do that? If you could forward is it in an MP4 format?
Yes.
Oh, okay, so if you could do that, and then if I could just, I don't know that if I'm watching it in an in-camera sort of setting, if we could just clear the courtroom.
Okay, yeah,
Or do you want me to just play it, I'm gonna watch it on my screen here.
I'm fine with that, Your Honor.
Okay, all right.
And I did get a text, it can be interpreted a couple different ways, I'm gonna try to find out. I know that the CAD company has been there, but I don't know exactly what that means. I think the first cab that they sent was not equipped for a wheelchair.
I see. Okay, so I am, just so that the record is clear, I'm going to play this right now. This is obviously not going to be shared with the live stream on YouTube because it's going to be played on my computer. And Ms. Watt, I'm assuming that is without objection from you?
Yes, Your Honor.
Mr. Prosecutor?
Without objection, Your Honor.
Okay. Has your client had an opportunity to see the interview?
I believe he's seen it recently. Your Honor, just for the record, my client has seen the video several times.
Okay.
He has not seen it very recently, but he has no objection to the court reviewing it.
Okay.
Okay. So, like I was saying, as you, born February 15th, 1960, right? Have the rights remain silent. I have to answer any questions put in here, make any statements. Statement I make or anything I say will be used against me in the court of law. Right to attorney present before and during the time I answer any questions or give any statement. I can't afford an attorney to be appointed to you without cost by the court prior to any question. decide at any time to exercise my rights, not answer any questions that may be speak. And, just sign this. This is here, I understand that these are my rights under the law. I'm not like threatening, promising, so I agree to answer any questions that may be speak. Now, if you decide to do that, you can sign right there. And, do you read right? Read. Okay. Alrighty. So we're talking about who's the simple. We're talking about what happened on Fairmont. Okay. And, what happened on Fairmont? Oh, by the way, they know you by, Mike Jones? Okay. Right, what, about 25 years or something? Three of them out there in the trial with drink, two of them may want, one at a time. Chairman and some other. Who's a big guy? Is that Julio? Yeah, I guess so, yeah. All right. And you, what do I have to do with the beard? Was he the skinny dude? Yeah. Okay. He does. Another guy. What's her name there? Michelle? Yeah. They was three of them up there. Kind of the top. Okay. Now you take care of Connie? Yeah, I can take care of her. Like help her with herself, like she's in wheelchairs, she has a diaper and that, you help her with it. You help her change and stuff like that. Okay. They got bargain. They got bargain outside. They brought it in. Who was Michelle? Julio? Yeah. Michelle. Julio was a big guy. He had like 6'3", something like that. Big. Yeah. Okay. And he whoops on her sometimes? Yeah. They call the police all the time. Okay. They got to it. So you're sitting down, and he cocked the first one? Yeah. So when he did that, go out. Okay. Was he on the stairway? No. He wasn't on the stair. The bed here. You go up there. That's the down floor again. I ain't never, that's it, that's it. Explain. It went back. Explain to me how he was acting. They had to drink some weed. Okay, so he was drunk? Yeah. Were you drunk? No. Okay. No. And, did he hit you? I got him before he came down. Okay. Yeah. How many times did you shoot? 5 times. 5 times. Okay. Were you scared? No. Were you scared that it was gonna hurt you? Only my leg. Okay. If you think I'm lying. No, I don't think you're lying. I know they're crazy over here. Oh. The policeman called over on them fools a bunch of times. Then one time I was there, Michelle jumped up Connie. You know Connie in the wheelchair. They're cousins or something. Yeah. She jumped up Connie, took a battery out of her phone, and they tried to call the police. They took her to jail. Connie went on first charge. Now, where did you get that gun from? From Grasher and 8 Mile. Oh, you bought it at the Action Movie? Yeah. What kind of gun is it? 380. And they took me, take it down to the police station to get a copy. The copy's in my wallet. Okay, so they sold it to you, you bought it brand new or? Yes. Yeah. She invited out the street. It's registered to you? Yeah. Okay. All right. So after you shot Julio, what'd you do? Yeah, I found out. Okay. You didn't think that it was a good idea? You didn't think that it was a good idea to call the police or something, say something happened? Yeah. Yeah, well, see if we can unscrew this up. You know, I don't know. No, I mean, I appreciate you being honest. You know, I appreciate that. I can't give you no legal advice. I know that. You know, I know what I'm going to charge you with. I'm going to tell you that. I'm going to charge you with attempted murder and carrying a concealed weapon. Okay. Now, I'll tell you right now, Julio ain't looking too good. Right? He ain't looking too good. I don't know how well.
I just need one moment.
I did want to know that. So I think that's pretty much it, Mike. He just got out of the penitentiary. He just got out of the penitentiary. He saved the thing. Yeah. Well, he just got out of the penitentiary. He said 7 years or something. Where do you labor in jail? Yes, sir. So, okay. Yeah. He just brags about it. Oh, yeah, and a couple of months ago, I used to stay there. Yeah. And the reason I left was they kept calling the police. And me and Tanya was just before Tanya got sick. And this was maybe in February or January. And Tanya said in the bed, he comes in there kicking the door. Huh? Talk about somebody talking about it. Now, Connie, it's your girl. Like, you know, all the time, your friends, whatever. I just had bought her stuff. The same day, just stuff up. Bought her stuff. Went to pay the front bill for it. Went back to drivers and stuff. No?
Well, they don't pay no rent. Whose house? No. So anyone? No. Social security or Section 8? Okay, well, yeah. I don't even know what to ask you, no more. You told me everything I want to know. They do know. They're supposed to come in, going in and out. Yep. That's definitely true. All right, so here's what we'll do. I'm gonna have Joe get in contact with you, all right? Joe Wright, Sergeant Wright, yeah. Now we're gonna figure out what to do for a car. Well, you know, but you're gonna have the title of your name, yeah, the title of my life. Title of my life. I mean, they put it up for safekeeping. So I got, yeah. So I don't know how long you'll be here. You know, the next step will be before the judge. And probably in the morning, most likely, your reading of the charges is what they call it. You know, decide what your bond. Whether it's easy to get out or you have to stay, and I don't make that call. You know what I'm saying? But in good work, you see, I never. Oh, you have something old from larceny in the building from way back when. I don't know. It was like an 80s, 90s. So okay. I don't even know what it was. That's the only thing. That's the only thing you had in the record. Okay. Nothing violent. No. Oh yeah, my child. No, I was talking to them. So, you're not my source. No. So what did you do? Maybe you want to attack me? But it's just like, it's like it's something else. Yeah, I know. It's true. Like, yeah, I mean, we could always relax. Yeah, I couldn't leave. Because where the bed sitting there, I couldn't get out. So what did he do after you shot him? Turned around, went up the steps. Did you shoot him where after he went right down the steps? And called my family, my job. Yeah, I'll stop by there. No, he doesn't know that. I'll stop by there. Tell him to put my bike back up in the garage. Would you do that? Sure, I'll do that. All right. I'll have to go up there. Around 8. We had a good day. Monday, we kind of had a good day. They sit out there driveway, just drinking, smoking marijuana. They smoke other stuff too? You see other smoke that crack? Yeah. I should know how to win. She was working at a restaurant down there on Kelly, but auto shop. Okay. They fired her. They were drinking and being adults. Hey, it was your phone. 313. And what's the name of that car wash you worked in? The number's in my phone. Yesterday on my phone. Who's your boss? Sam. Where do you use the address on Tepper? Yes. 72166. You see where you stay there? I don't really stay there. That's on my job. Okay. You stay over on Tepper? No, I don't stay on this. I stay on Towers, St. John. There's a church that shelters. You know, staying in the house on Tepper? almost 30. Yeah. This is service down there from last week. At the gas station. I'll go with that. Well. All right, so is it my son? That's not for me. I mean, it really isn't. Because so it's gonna be your word against his. Now, hopefully, Julio makes it. Right now, there's a whole liver, belly. I can see a blood infection now. So I don't know. We'll see. We'll see. All right, thank you. All right, sir. All right, so. Well, that's where you're at. You know. South, county. And then I'll tell them where you're at. All right. Get my car. I will. All right. I'll make sure you stay. The title. All right.
Okay, everyone has left from the interview room, but it looks like there's about maybe 60 more seconds. Did you want me to keep watching it, Ms. Watt?
No, Your Honor.
Okay. Oh, actually, it just stopped. All right, with that being said, I'm gonna hand the disc back over to the prosecution. Well, what is the status on your witness?
Your Honor, so I was texting with Sergeant Eby, who is part of the homicide task force. And as sergeant, he is in some sort of supervisory capacity. And I'll read some of the texts. I said, are the ladies on the way or is the cab on the way? And he says, cab on the way. I am on street near the house, but I forgot she is wheelchair bound and needs a minivan. I said, okay, thanks. Is there an ETA? And he said, Checker said that they will be at her house in 15 minutes. I said, thanks. And then he said, Checker arrived and somebody told them they already left. And I responded, I'm unclear. Does that mean that the ladies are on the way? And I sent that text at 2:37, so about 20 minutes ago, and I haven't heard back. Talking with my officer in charge who is here, she tells me that a suspect on another homicide was just taken into custody, and Sergeant Eby is probably tied up with that, which means that which might explain why I'm not getting a response when Sergeant Eby and I did have a dialogue going. So with that being said, the way that I understand that last text, it sounds like the cab was there, somebody said that the girls weren't there, and it sounds to me like the cab probably left without the ladies. So, I mean, I apologize to the court, I apologize to Ms. Watt, I apologize to Mr. Sankey, but I think I've gone as far as I can today. These are circumstances that are beyond my control, unfortunately, but I do realize that they reflect on the people.
What are you asking for?
So with that, I would have no further questions for Officer Townsend. I'll turn over for cross-examination if Ms. Watts has anything. But at that point, once we're done, I would ask for a recess and maybe schedule another time to come back.
Okay. Would you care to cross-examine?
I don't have any further questions, Your Honor. You've had an opportunity to review the video.
Okay, thank you. You may exit the courtroom, sir. And it sounds like we need to, are you requesting an adjournment for the balance of the exam?
I am, Your Honor. So I would have two more witnesses, and as I said, they're cousins, they live together. If I have one, if I get one, I'll get both of them. So it's just a matter of finding out when we can come back, and I'll move heaven and earth to make sure that you're here.
Madam Defense, your response?
Your Honor, we're ready to proceed. I'm objecting to any adjournment. We're ready to proceed today, Your Honor.
So this is what, I am comfortable with granting adjournments so long as I can have some level of information on the record that rises to the level of good cause. So, and I may have misunderstood, but, and I know that you're trying to get feedback from someone who isn't here, but is the representation that you believe the cab that was scheduled to pick them up came and that they were not there, such that you don't know if they are cooperative and?
Oh, they are cooperative, Your Honor. They came and testified in, I think it was October of last year, when this matter was still just an assault with intent to murder. So they are cooperative. They have come down to testify in the past. It sounds like they were unclear, according to my officer in charge, and Officer James was there as well when they were served. According to my officer in charge, they were not aware that Mr. Ramos had passed away. They were upset about that. They had known one of them was in a dating relationship with Mr. Ramos. So I have no doubt that they will be here, and unfortunately, this is a mix-up more between my office and the Detroit Police Department as far as arranging transportation.
And you have no direct contact information with these one or two of these witnesses?
I had called them earlier today and left a voicemail, and I have not heard back from them.
And Your Honor, I'm still unclear. Is it that, okay, I know a cab initially came, they didn't take that cab. So was a second vehicle sent that could accommodate a wheelchair?
And
I'm unclear too.
And I mean, if you would like, I can read into the record the communication, word for word that I've had. I am a little bit unclear as to that myself.
Okay, what I would like to do, as opposed to doing that, I'd like to take a 5-minute recess.
Yes.
And see if you can reach this corresponding officer and find out something so that we can have something definitive on the record before I make my decision.
Certainly.
Okay.
Okay, Your Honor, I called Sergeant Eby's cell phone and one of his colleagues picked up a Detective Lane, and it is correct that Sergeant Eby is tied up on another matter and cannot get away. Detective Lane is familiar with what's been going on, so I did get an update from him. They did send out a second cab. Police officers are from the homicide unit are no longer on the street, as one of the texts indicated, because they are dealing with whatever took them is occupying Sergeant Eby. The cab company called Sergeant Eby and said that when the second cab arrived, they made contact with somebody inside the house who said that the ladies were not there, they had already left. I checked with with the security staff here in the building to see if there was anybody in line that matches the description of one female on foot and another in a wheelchair. And I was told that there is nobody downstairs in line meeting that description. So, Your Honor, I guess at this point, the people would ask for the adjournment. I do note that Mr. Sankey is currently serving a 10-year sentence in Michigan Department of Corrections. So it's not like he would be released. We're not inconveniencing him. I mean, we are, but not to the point where it is affecting his liberty. So given the seriousness of these charges, given the efforts that I and the police department have put in, through unfortunate circumstances, a cab was ordered, 2 cabs were ordered, and for whatever reason, it never came to fruition. As I said, in my experience, in my contact with these 2 witnesses, they have been cooperative every step of the way. I don't have a good explanation as to why they are not here, but I can rest assured anyway, that they will be here at the next date if I have to go pick them up myself, although I don't know if my office would allow me to do that. So with that, Your Honor, I humbly and respectfully request an adjournment to some time when we can come back and complete this matter.
Okay, and I'm assuming there's a continuing objection and a movable petition for dismissal.
Yes, I mean, initially, the prosecution had indicated that they could go forward with the evidence that they had. So, I don't believe that the standard is whether or not Mr. Sankey is inconvenienced, but whether or not there's good cause. And Your Honor, I do have a continuing objection because it appears that 2 cabs were sent and the witnesses are still not here.
Thank you. So, the interesting part of it in determining good cause is not only, you're right, not only is this inconveniencing Mr. Sankey's liberty, but also coupled with the efforts that have been made. If there had not been this background of information where the witnesses had been in communication with the prosecution and had indicated their cooperation, I do not believe I would be granting an adjournment, but there has been. And I suspect it's quite possible that after the first cab came that could not accommodate the individual with the wheelchair, that perhaps they attempted somehow to try to get here on their own, which is why when the second cab came, they were not there. Again, I don't know, like I'm only just making assumptions here, but given the background of information provided by the prosecutor that these 2 witnesses are cooperative witnesses, they needed this transport to the courthouse, and the prosecution had made every effort to make that happen. But given the circumstances, I am going to provide an adjournment in this matter so that those witnesses can be brought forward. I don't know when we can do this. In fact, to find an afternoon.
I'm going to be gone starting next Monday, this coming Monday, until August the 11th.
Okay, so is there, I don't think we have an afternoon probably until September.
Are you looking at the beginning part of September or middle or?
I went through the last week of August and I'm just hitting every day till I come up till the afternoon. We have exams scheduled every afternoon almost.
I know you do.
So whatever first one comes up.
Okay.
reason why I would like it to be in the afternoon is because to schedule it for the morning is so chaotic that I would hate to have the witnesses get here and then we can't really accommodate the timing of the exam. An afternoon would be better.
Understood.
23rd, September 23rd at 1:30.
That works for me, Your Honor.
That works for me, Your Honor, and I appreciate the court's flexibility and I appreciate Ms. Watt's flexibility as well.
Okay, the continuation will be for September 23rd at 1:30 in the afternoon in person.
Thank you, Your Honor.
Thank you.
Thank you.
Enjoy the rest of your afternoon.
You too.